You guys
Good morning. Are y'all able to hear me?
Yes, I can hear you.
Good morning. I'm Eric Blank, and we're back on the record in Public Service Company's DSP filing 24A-0547E and VPP 25A-0061E. Before we get into it, just a couple comments. I think given the pending 3-day weekend, I'd love to break at 3:15 or 3:30 today. I think we're making enough progress that that still works comfortably for our schedule. So I assume that's not a problem for you, Commissioner Bland or Commissioner Gilman. And then before we get back to Ms. Bloch, any preliminary matters? Mr. Larson, they're bringing out the big guns.
Stay away, Mr. Chair.
Could stay away.
Few preliminary matters if now is an appropriate time.
Yeah, now would be great. You want to start, Mr. Larson, and then we'll jump to Mr. Dixon?
Yes, sir. So we have 4 different hearing exhibits that we'd like to move into the record, and I can step through them. We continue to work on a couple of others, and I can provide an update on that at the end. But the first one is in our box. It is marked as hearing exhibit 103. It is a Rev 3 to the distribution system plan, which was attachment ZDP 1. This was a correction that was discussed during the examination of Mr. Pollock. So that's the first exhibit. The second one is in our box, marked as hearing exhibit 140. And that's the heat pump rebates that have been paid through August 27, 2025. The third document is hearing exhibit 141, which is the AVPP targeted feeder list that is current as of August 28, 2025. And then we have the Excel Q4 2024 earnings report marked as hearing exhibit 142. And we would seek administrative notice of that. So we wanted to handle the 4 of no, apologies, that 141 is a confidential exhibit.
I lost you. What did you say about 141?
141 is a confidential exhibit. I just wanted to reflect that for the
Okay. Any concerns from the parties about admitting all those documents? And to the extent the parties haven't seen them, we can admit them or take administrative notice subject to review. So any concerns at this point? Ms. McLaughlin?
I would just say that we haven't been able to see those. We don't have any concerns about the rev of the DSP plan. I think that was one, I forget the hearing exhibit that Mr. Larson used, but we haven't seen 141 or 142.
All right. Well, so Mr. Larson, if you could just make sure all the parties, including Commission Counsel, have access to the documents. And Ms. Dundas, if you can send an email with those documents to the commissioners, that'd be great. And then Mr. Larson, maybe at the next break or lunch, we can get those admitted. Would that work?
Yeah, that sounds good. We will circulate 140, 141, 142 to counsel for the parties plus Commission Counsel. And then we also continue to work on the service applications and the updates to the McDermott table. I anticipate we'll have those ready, prior to the close of the hearing, and I can keep you informed on that.
That'd be great. And just so you know, Mr. Larson, in the wake of Commissioner Gilman's questioning of Mr. Mino, I think this is good, Commissioner Gilman. It raised some questions for me and advisors. So we may on Tuesday want to bring Mr. Mino back. I'll know by the end of the day. It won't, and he doesn't have to listen to today. He's there will be no expectation that he will have heard what happened today. But a handful of follow-up questions. So we'll know the scope by the end of the day.
Perfect. Maybe we can check in right before we break this afternoon and come up with a plan to bring him back.
Yeah.
If he does need to come back.
Yeah, with apologies. He's had a long day. All right. Anything else, Mr. Larson, before I go to Mr. Dixon?
Nothing further from me.
Mr. Dixon,
I
did you
just
have?
want to let you know I'll be covering today's hearing, and Mr. Wittershine will likely not be on the hearing. So I just wanted to advise you I will be working for the UCA today.
All right. Everybody's bringing out the big guns.
Well, they're bringing out the old guns here.
The old guns. All right. Thank you, Mr. Dixon. Ms. Bloch, you still there?
I'm still here.
Do you understand that you're still under oath?
I do.
Thanks. I think we're up to me. So I'm just gonna have a few questions following up to what I asked Ms. McDermott. And the other day, I believe that Ms. McDermott generally acknowledged that the grid modernization statute had language, Section 1A6, saying that new customers must be able to connect to the electrical distribution system, and existing customers must have their service levels promptly upgraded. I can pull up the statute if you'd like, but would you accept that characterization of the statutory language and requirements?
I will.
Thank you. I believe that based on the staff's customer care and billing issues report for public service, summarized in hearing exhibit 2307, Ms. McDermott also seemed to acknowledge the following. One, that customer complaints about public service filed with the Colorado PUC have more than doubled from 2022 to 2024. That overall customer satisfaction has fallen by 17% from 20 to 2024. That PSCo's average response time to respond to a customer call in 2024 was over seven minutes, or an increase by a factor of 10 since 2014, and well above the levels required in the quality of service plan. And four, that the company terminated 200,000 calls in 2024, or over 4 times as many calls as from 2022. Given that these findings were based on company data, do you have any reason to believe that these staff findings are inaccurate or that I've mischaracterized them in my summary? And again, I'm happy to pull up hearing exhibit 2307 and walk you through one by one if that'd be useful.
Nope, I have no issues with the way you laid that out. I'm sure it's correct.
Okay. Along the same lines, in just the last 60 days, we've gotten several letters from both existing and new potential large commercial customers that I would view as credible entities. These entities allege similar concerns about billing mistakes, lack of transparent communication, design errors, last-minute scope changes, and chronic inefficiencies that have created significant harm to these customers. Although I don't think these alleged claims have been meaningfully validated, there are clearly some very unhappy large customers. Given the staff report, can you help me understand what has caused this apparently significant deterioration in customer service over the past few years?
I know that Ms. McDermott did punt this to me. I'm also not in customer care, but I have been assured that Mr. Piquet can ask these questions. So I hate to punt it again, but I'm sure
we'll keep following that. We'll keep following this where it goes. But all right, I think this one may be the right person. Given the company's apparent struggles with these most basic customer service issues, any assurances you can give me that the company is going to be able to cost effectively manage the multi-billion-dollar distribution construction budget, the distribution capital spending budget that you're asking us to approve in this proceeding?
Yeah, I think that's a good question. And it's one that we gave a lot of thought to as we were preparing these budgets. You know, do we have the manpower to effectively execute on this? How what do we need to do differently to ensure that, you know, these will be well managed and cost effective. In my testimony, in my direct testimony, I do talk about some actions that we've been taking as a company. You know, we know that to ramp up into these levels that, you know, we're going to need to think differently about how we go about design and construction. We are working with some design build contractors to help us and supplement some of our resources that we have on here. We're also, you know, there's been a lot of discussion over the course of the week, really wanting to make sure that there's not a lot of overlap in this budget, that, you know, that we're coordinating our planning. We've spent a lot of time and effort focusing on making sure that there are clear lines of who's doing what, but also that we're coming together when we have these plans for the budget, and that we're ensuring that either there's not overlap or we're looking for synergies on where we can combine work together in a single work package to get the work done more efficiently.
I mean, I guess given this company struggling to answer the phone, just any doing billing, just any confidence you can give us that these problems are going to improve and that we're not going to see the same thing only multiplied by a factor of 10.
Yeah, again, in terms of the customer care, I really do have to point you to Mr. K. I'm just not in a position to talk through it, but I understand that he is.
Okay, thanks. Mr. Simpson, redirect.
Thank you, Chair Blank. This will be brief, Miss Bloch. There's been a lot of talk with respect to safety, reliability metrics, those sorts of things. And with respect to the asset health and reliability budget, does the preventative maintenance type of work that you really do and or the replacement work that you really do tend to increase safety and other reliability metrics, or does it really help prevent degradation of those metrics?
You know, a lot of our basic programs are geared to preventing degradation, but we do have some programs that we do, and that depending on the funding level, we can and do see improvements.
And with respect to pole replacements, there was some discussion, but if you replace a pole before it breaks, would you expect to see a reliability metric improvement by doing so?
No.
Would you expect to see reliability degradation by doing so?
We would have degradation if we didn't do it, because if we weren't replacing that pole, it would eventually break and cause an outage.
I have nothing further.
Right, thank you.
Ms. Bloch, can't quite excuse you yet, but no expectation that you need to listen to the hearings further. And if we do need to bring you back, it'll be with the understanding that you haven't heard what's happened between now and then. So
Right.
thank you.
Thank you. Bye.
Bye. Ms. Chacon.
Good morning.
Morning. Can you hold up your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
You can put your hand down. Is anybody with you or communicating with you in any way?
No.
If that changes, will you let us know?
Yes.
With that, back to you, Mr. Larson.
Thank you, Mr. Chair. Good morning, Mr. Chacon.
Good morning.
Can you please state and spell your name for the record?
Yes, my name is Beth Chacon, Bethchacon.
And what is your role at the company?
I am a director of DER integration and system performance.
And do you have before you what's been marked as hearing exhibit 108, which is your direct testimony, and hearing exhibit 127, which is your rebuttal testimony?
That is, yes, I do.
And were those prepared by you or under your direction?
Yes,
If I asked you those same questions today, would your answers be the same?
yes.
Those exhibits have already been admitted into the record. And with that, Mr. Chair, Mr. Chacon.
I have ACE 30 minutes and it's a little after 9:15. Ms. Coetzer.
Thank you, Mr. Chair. Good morning, Ms. Chacon. It's nice to see you again.
Good morning. Nice to see you.
For the record, I'm Ellen Howard Coetzer. I represent the Associations for Clean Energy, or ACE, in this proceeding. And Ms. Chacon, I'll be talking with you today about flexible interconnection exclusively. So to lay a foundation, both you and Mr. Pollock submitted rebuttal testimony addressing flexible interconnection in this case, correct?
Yes,
Were you listening to the hearing when Mr. Pollock was cross-examined about the company's position on flexible interconnection?
yes, I believe so.
I don't know who's driving today for the legal assistance, but could you please pull up hearing exhibit 1405, which is the statute? I've also got another copy in our box if necessary. Could we turn to page 12, please? And I'd like to go to the bottom of the page to Roman numeral 4. If we could get all of it, that would be great too. So Ms. Chacon, can you take just a moment to familiarize yourself with this language?
Okay.
So Ms. Chacon, if you were listening to the hearing when I was cross-examining Mr. Pollock, it's my understanding that the company is interpreting this portion of the statute to rely on the phrase phased interconnection or energization agreement as its method of compliance with SB 212 as it relates to a flexible interconnection tariff. Is that correct?
Yes, the tariff or agreement. So, or being a keyword. And that agreement was something that was proposed in Piesco's res plan that's currently underway.
We'll get there in a moment. You're anticipating my question. So again, I just want to establish you're hanging your hat on the or agreement or energization agreement in the language in the statute, correct?
I'm not sure what hanging hat means in this case.
Let me be less colloquial. You are relying upon the phrase or energization agreement as your method of compliance, correct? We've established that already.
Yes, and again, I'm not the regulatory or legal expert.
Understood. And let's turn now, since you mentioned the res plan proceeding, to what you have filed in the res. So it's correct to say that in your rebuttal case, you direct interveners such as ACE to address their concerns about the flexible interconnection tariff to the RE plan proceeding, correct?
I'm not sure.
We could pull up your rebuttal testimony if you need a refresher. Could we please go to hearing exhibit 127, page 9? Thank you. And Ms. Chacon, if you could refamiliarize yourself with your testimony at line 14, I think that's where it's located.
Okay.
So it sounds like based on this language in your rebuttal testimony that you have some familiarity with the filings that have been made by the company in the RE plan proceeding. Is that correct?
That is correct.
Let's go ahead and take a look at what's been filed. Ms. Federico or whoever's driving, could you take this down and please turn to what's been pre-marked in our box.com folder as hearing exhibit 917.
Okay, that's not opening. I'll just have to try another way. Just give me a minute.
And Ms. Chacon, while we're waiting, I'll let you know what we're pulling up is volume 3 to the company's renewable energy plan. It's a big document, so I'm sure it's thinking hard. So Ms. Chacon, as I just asked you, can you confirm that this is indeed volume 3 to the company's renewable energy plan?
Yes.
And let me represent to you that this document combines several model contracts related to distributed renewable energy, but let's turn to page 219. Can you confirm that one of the model contracts contained within this larger document is the company's standard DER interconnection agreement?
Just looking at this
Sure.
agreement. Yeah, this appears to be, so your question was, again,
Does this appear to be the company's distributed energy resource interconnection agreement?
it does appear to be that.
Okay, great. And we'll get into this in a moment. Could we now go to page 248? So here I see that we have what's been labeled as DER flexible interconnection terms and conditions. Do you follow me?
Yes.
And so I'd like to establish that it's these DER flexible interconnection terms and conditions that are the energization agreement that the company is, arguing is compliance with SB 218. Is that correct?
I'm going to object based on foundation, calls for a legal conclusion. Ms. Chacon's not a witness in this proceeding. That's being referenced on the screen.
Could I respond?
Yeah, of course.
There's been quite a lot of back and forth with this. Ms. Chacon did testify as to the RE plan proceeding in her rebuttal case. She's already testified that she's familiar with that proceeding. She's already testified that she's familiar with this hearing exhibit. I think it's critical to establish what the company is using as compliance, and Ms. Chacon is the witness available to do that.
Overruled. You may need to repeat the question.
Sure thing. I'll do it again. Ms. Chacon, can we confirm that it's this DER flexible interconnection terms and conditions that the company deems to be the energization agreement required for compliance with SB 218?
Yeah, that's my understanding.
Okay, great. Mr. Chair, I'd like to move to admit hearing exhibit 917.
Mr. Larson?
No objection.
So moved.
Great. So let's turn back to the document on the screen here and ask you a couple of questions about this agreement. If you're able to answer, Ms. Chacon, it wasn't clear to me looking through the entirety of this volume 3 that these DER flexible interconnection terms and conditions, what kind of contracts they'd apply to. As I scanned through the document, we introduced the DER interconnection agreement, right, on page 212. And then we've got these terms here kind of sitting out on their own without labeling as to being any sort of attachment. Can you explain how these terms and conditions will interface with the other documents that are a part of Volume 3?
What other documents were you thinking?
Can we go back to page 212, please, Ms. Federico? Let me make sure I got that right. Sorry. 219, I apologize. So Ms. Chacon, we already talked about the Distributed Energy Resource Interconnection Agreement. Agree?
Yes.
So really my question are these flexible interconnection terms and conditions an attachment to this contract?
Yes, I believe that they were intended to be combined. So the interconnection agreement exists, and then the flexible interconnection is a companion to that.
So is the flexible interconnection terms and conditions only an attachment to this agreement, or would it be used in other contexts?
So can you repeat the question, please?
Yeah, my question is, will those flexible interconnection terms and agreements, terms and conditions only be an attachment to this Distributed Energy Resource Interconnection Agreement?
I believe so. I haven't, yeah.
So you would not use those terms and conditions in other contexts, such as agreements to interconnect load?
Which agreements?
Hypothetically, let's say an electric vehicle charging customer wants to interconnect new load to the system. Would the flexible interconnection terms and conditions we just went over also apply in that context, or are they only applying in the DER interconnection agreement context?
I believe that what was proposed in the plan is intended to be used for the use of the interconnection of generation.
So only the interconnection of generation. That's your testimony?
Yes.
Okay. Let's move on from here. Are customers who are interconnecting generation to the company's system able to negotiate the terms and conditions of the flexible interconnection agreement?
I don't know.
Is that an open question that COSA could ask witnesses in the res, or who else at the company might have the answer to that question?
Objection, scope, asked and answered.
Overall.
Okay, so I'm sorry, can you repeat the question?
Sure, I'm just trying to understand who at the company might be able to ask my question, if you don't know the answer.
And your question was?
Are parties able to negotiate the flexible interconnection terms and agreements?
I believe that there's an opportunity for parties to comment on that in the res plan.
So right now it's a litigated issue within the res, and the only opportunity to weigh in on those terms and conditions is through litigation in the res. That's your answer?
No, I guess the reason, as Mr. Pollock, testified yesterday, the intent of using an agreement was in case there is a need to change terms as we're going through a new process, just to make sure that the deployment goes smoothly.
Okay, so there may be an opportunity outside of litigated context for parties to negotiate that agreement. That's your testimony?
That was the intent.
Okay. Ms. Chacon, based on your experience and position, do you agree with me that flexible interconnection agreements could allow renewable energy generation project developers to complete project construction even if they were waiting on the company for a system upgrade?
Yes, and could you please repeat that?
Sure. Would you agree with me, based on your experience and position, that a flexible interconnection agreement could allow a renewable energy generation project developer to complete project construction, even if they were waiting on the company to complete a system upgrade?
Yes.
So that in turn could help that project qualify for expiring ITC tax credits, even if there were delays upgrading the company system, correct?
When you say that, what were you referring to?
Sure. As you are well aware, there's been a lot of changes to national tax policy related to the ITC tax credits. And my question really relates to, could flexible interconnection help a project comply with the changed ITC tax credit eligibility requirements, because it would allow project completion, even if that project were waiting on company upgrades?
So you're asking whether a flexible agreement can help us comply with tax laws?
I'm asking if a flexible interconnection agreement would help a project complete construction. And it's in your prior testimony was that yes, it would. Is that accurate?
Objection, speculation, misstates the witness's testimony.
Might I respond?
Yes.
Just asking Ms. Chacon to confirm what she already testified to. She's welcome to do that. She's welcome to correct me.
Overall.
So a flexible interconnection strategy, I guess to your question, can potentially help bring a project on sooner.
Great. Let's move on from here. Casey, Ms. Federico, excuse me, could we take this down? And I'd like to turn back to the statute hearing exhibit 1405. This time I'd like to take a look at page 8. So Ms. Chacon, I'd like you to familiarize yourself with subpart U, which is the statutory definition of phased interconnection or energization agreement. Could you please do that?
Okay.
So, Ms. Chacon, we already established that the company is relying upon its filing of an energization agreement in the Renewable Energy Standard proceeding as its form of compliance with SB 218. Do you recall that conversation?
Yes.
So here, looking at the screen, the statutory definition of a phased interconnection or energization agreement means it's an agreement between a utility and a customer to provide certain levels of electrical service capacity on a guaranteed timeline in exchange for the customer participating in the qualifying retail utilities flexible interconnection or energization tariff. Did I read that correctly?
Yes.
So in the statutory definition, participating in an energization agreement is predicated on the customer's agreement to also participate in a utility's flexible interconnection tariff, correct?
You're going to have to repeat that, please.
Yep. In the statutory definition of phased interconnection or energization agreement that's here on the screen, participation in that agreement is predicated on the customer's agreement to also participate in a flexible interconnection tariff, correct?
Mr. Chair, I think that Ms. Kutzer is asking the witness to interpret the statutory provision with this question.
Can you rephrase the question? I just want to hear the question.
Yep. So looking at the definition of phased interconnection or energization agreement from the statute, which is here on the screen, participation in an energization agreement must be predicated on the customer's agreement to also participate in a flexible interconnection. Correct, Ms. Chacon?
I'm not sure what the language is intending to imply from a legal standpoint.
Well, let me represent to you that the way that ACE is interpreting this portion of the statute means that you can't have an energization agreement without also having a flexible interconnection tariff in place.
Object to the form. There's no question, and she's offering ACE's own illegal interpretation.
It just rephrase in the form of a question.
Sure. Ms. Chacon, do you see here within the definition of phased interconnection or energization agreement that the definition also relies upon participation in the qualifying retail utilities flexible interconnection or energization tariff? Do you agree with me that that is the language on the page here that we're both looking at?
I agree the language is there.
And just to confirm, the company is not filing and has no plans to file a flexible interconnection tariff with the commission. Is that correct?
Yes, that is my understanding.
Let me represent to you, Ms. Chacon, that COSA supported the passage of SB 218, and ACE witnesses Joan White and Sam Weaver are both specifically supporting the company's forward-looking investment in its system in their answer testimony. Recognizing that background, can you understand our frustration that the company is also not holding up its end of the bargain and bringing forward measures required by statute that can help reduce capital spending, such as a flexible interconnection tariff?
Unfortunately, you cut out for a second. So I wanted to make sure I didn't.
Sure. I'll be more direct, Ms. Chacon. Can you understand our frustration with the fact that the company is not bringing forward potential cost-saving measures, including a flexible interconnection tariff as that's required by statute?
I guess I don't know.
Okay, let's move on from here. Thanks, Ms. Federico. We can pull this down. Ms. Chacon, in your testimony, you also talk about some of the pilot projects for flexible interconnection. Do you recall that portion of your testimony?
Yes.
And in your rebuttal on page 12, we can pull it up if we need to, you state the company has had positive experiences with developers with whom we've worked on demonstration projects. Do you generally remember making that statement?
I'd like to see it, please.
Sure. Could we go back to the rebuttal testimony? I believe that's 128, page 12. I may have written down the wrong page number, but do you generally recall that you testified as to the demonstration projects that the company's working on?
I would like to see the section of the testimony that you were referring to.
Sure. Could you scroll back up, Ms. Federico? I apologize. I may have written down. Could you just go ahead and look at, I think we're there at line 17 on 11. Sorry about that. Ms. Chacon, I had asked you if you testified that the company has had positive experiences with developers with whom we've worked on demonstration projects. Do you see that is here on the page in your testimony?
Yes.
Okay, great. So Do you recall that you testified as to 2 demonstration projects in your direct testimony? I'm hoping we don't need to pull that up.
Yeah, I think we might need to.
All right, I'll go to the attachment. Actually, I think that's the most sufficient. Hearing Exhibit 108, attachment BJC-1, page 7. So again, Ms. Chacon, I'm just going to ask you about the 2 pilot projects that the company is pursuing for flexible interconnection.
Okay.
It was Ms. 7, page 7, Ms. Federico, thank you. So here I see proposals moving forward to demonstration. There's a Pivot Energy Smart Controls for Flexible Interconnection project and an Encore Targeted Least Cost Electrification Planning via Gas and Electric System Simulation project. Do you agree that's here in your testimony?
Yes.
I'm going to ask you only about the Pivot project. You're familiar with that project, correct?
Yes.
Okay. Has a flexible interconnection agreement been signed with Pivot Energy for this pilot project?
No, we're still exploring which project to move forward and study further for the flexible connection.
So have you been negotiating flexible interconnection terms for that project with the developer?
So we're at the stage where we're really looking at the project itself.
So you haven't had any discussions about flexible interconnection terms and agreements with the developer to date. Is that your testimony?
No, that is not.
Can you explain to me what kinds of discussions you've had about flexible interconnection terms and agreements?
I believe that we sent over a model contract to them.
Did the model contract match the model contract you and I discussed earlier that we pulled up on the screen?
No, it didn't. It was sent over as a markup for them.
Okay, so the exhibit that you and I went over earlier today does not represent the potential agreement that you're negotiating with the developer. It's different, correct?
You know, we had put the agreement on hold. So we haven't really talked about the agreement since what has been filed in the res plan, at least to my knowledge.
Okay. And what's the status of the negotiations about that agreement? You testified that there was a red line. Where does that stand today?
Again, it's been kind of put on hold until we talk about the project itself. Like it just hasn't really been a topic.
Okay, so just to clarify, this pilot project is not actually in operation and the company has not gained any experience operating this project under a flexible interconnection agreement. That's correct?
To answer your question, the pilot is not in place, but we are certainly gaining experience about flexible interconnection and the process and the technology and all those things.
How is the company able to do that if the project's not actually operating?
So we have to think about the actual operations of the flexible interconnection and how we might communicate to customers. So we're working on that piece.
But it's very early stage, is that fair to say?
Well, early stage is probably a relative term, but we are thinking about how projects, not only Pivot, but FI would be tying in with our systems.
Is that the only flexible interconnection pilot the company currently has on its system?
Well, it's not, the pilot itself is not on our system. And I'm just thinking about whether there are other flexible interconnections. We do have our small system FI
Okay.
demo.
Okay, Ms. Chacon, that's all the questions I have for you. Thank you for your time.
Thank
Thank
you,
you.
Ms. Kutzer. AEU, I have 20 minutes. Ms. Judkins.
Morning. Good morning, Ms. Chacon. For the record, I'm Sarah Jenkins, representing Advanced Energy United. Nice to meet you.
Nice to meet you also.
I would like to first focus my questions on recommendations regarding pilot projects and then turn to flexible interconnection.
Okay, but you cut out just for a second, so.
Okay. We'll start with some questions about pilot projects.
Okay.
Did you review the answer testimony of Mr. Vincent Fugetta on behalf of Denver?
Yes, I did.
And do you recall his recommendation that the commission approve a smart panel pilot program?
Yes, at a high level.
And we can pull up the testimony if that's helpful to you, but do you recall that Mr. Fugetta proposed that the company deploy smart panels with appropriate technologies and capabilities at households located on constrained feeders?
Yes, but I think I might like to see that testimony.
Certainly. Ms. Federico, could we please pull up hearing exhibit 701? Look at page 24. And if you take a look at lines 16 through 19 or so.
It's currently not showing up on my screen. So
Could
maybe
you scroll down a little bit, please, Ms. Federico? Thank you.
okay, that's part of it.
And I'm not going to get into too many of the specifics of his proposal, but no company witness responded to this recommendation and rebuttal testimony, right?
I can't say for sure.
Did you respond to this recommendation in rebuttal testimony, Ms. Chacon?
I did not.
And are you the company's witness on pilot projects?
Yes.
Okay. And I'll represent to you that I reviewed the company's rebuttal testimony for references or response to this recommendation, and I did not see any response. Do you have any reason to doubt that?
I don't.
Okay, thank you. So what is the company's position on Denver's smart panel pilot recommendation?
I think without, I guess, doing more diligence on the smart panel, I think it's something that the company can look into.
And can you explain by what you mean by look into?
So better understand the smart panel. My understanding is that they are installed at the customer home and have kind of an upper limit for how much load is being drawn.
That's my understanding too, and Mr. Fugetta describes that a little earlier in his answer testimony, although I'm not sure we need to scroll there. But would it surprise you based on your answer just now that Mr. Fugetta testified that smart panels can benefit the grid by aggregating many smart panels to mitigate peak demand?
yes, I guess if they could be aggregated.
And Mr. Fugetta also suggested, as you just suggested, that the smart panels deployed under the proposed pilot could be aggregated to act as a VPP resource in the future. Would that make sense to you?
I'm not familiar with all the details of the VPP program, so I can't say.
And it sounds like, based on your testimony, that you would agree that Denver's Smart Panel Pilot Program recommendation could help demonstrate the value of smart panels to the system, right?
As well, yes, as well as understand the costs to deploy and determine if they bring benefits as well.
Thank you. Let's turn now to flexible interconnection. So first, I'd like to introduce some terminology and see if we can agree on a couple of definitions to assist our discussion. So I'd like to distinguish between static and dynamic flexible interconnection. So when I say static, a static limit or static flexible interconnection, can we agree that I'm referring to an export or import limit that is pre-programmed into a power control system, so the limit does not require visibility or dispatch by the customer, aggregator, or utility?
Yes, can you please repeat that?
Yes, certainly. That was a long definition. Are you familiar with the distinction between static and dynamic limits for flexible interconnection?
Generally, I think there could be some nuances in interpretation of the terms.
Okay.
Industry.
Okay, so just to make sure we're talking about the same things in our discussion, for a static limit, I'm referring to an export or import limit that is pre-programmed into a power control system so that the limit does not require visibility or dispatch by the customer or an aggregator or the company. Does that make sense to you?
I'm not sure that the limit wouldn't want to be visible to the utility, but maybe I'm not understanding what you're trying to convey.
So I think the idea I'm trying to get at is that for a static limit, it's something that's pre-programmed and it's not it's programmed at the time of installation to limit import or export at certain hours. So it's not something that is dynamic, sort of day to day or month to month.
Yeah.
Okay.
Certain hours may not be, I mean, not everything would have that capability by hour, but perhaps just overall limits.
We can agree to that. So then conversely, referring to a dynamic limit, that means that the export or import limits can be dynamically controlled either ahead of time or in real time by either the company or a third party, such as an aggregator.
Well, I believe that I generally agree. I believe that the utility would want to specify the limit, not the aggregator. In terms
okay, but as a general principle, a dynamic limit is one that can be adjusted and controlled either ahead of time or in real time, right?
Yes.
Okay. In your rebuttal testimony, you mentioned that the company's grid DERMS implementation for flexible interconnection purposes, will begin in Q1 of 2026, right?
Yes. It was proposed that well, can you repeat the question, please?
Yeah, that the grid's DERM implementation will begin for flexible interconnection purposes in Q1 of 2026.
Yes, and the particular use case was for what was proposed in the res plan was some solar gardens projects.
Okay. And we'll get to technology type here in a little bit, but going back to our conversation about static and dynamic limits, would you agree that as a question of technological capability, static limits can be implemented without grid terms?
Yes, and the dynamic capability allows the use case to be more precise on the limits and allow more surgical approach with the DERM software.
I understand. But simply as a technology question, I believe you agreed with me that static limits can be implemented without grid terms, right?
That's correct.
Okay, thank you. Were you watching the hearing earlier this week, specifically Mr. Pollock's testimony?
For the most part, yes.
Do you recall that Mr. Pollock had an exchange with Commissioner Gilman where he appeared to indicate that the company is currently using static limits in some existing flexible interconnection agreements?
Yes.
And can you provide a little bit more detail about the instances where the company is currently using static limits in interconnection or energization agreements?
I will try. So we have, I guess Mr. Pollock may have been referring to some of the smart inverter settings and the autonomous settings.
And what technology types are those being used for currently?
So when you mean technology types, what?
So is the company using those static limits, for example, for small scale solar systems?
Yes.
And what about EV charging installations?
Do not know about EV charging installations.
And do you know about other types of load, like CNI, for example?
I don't.
And these are current examples of static limits in flexible interconnection that don't utilize grid terms, right?
Yes.
And do you know the process by which customers are identified and evaluated currently for these static limits?
So the autonomous settings themselves are something that is part of what we call our TSM DG manual. So it's something that they include in their, when they apply, they adhere to that.
Okay, and just so the record's clear, what does TSM DG stand for?
So it's the technical services manual. It's like a technical manual that one would review when connecting to DER to the system.
And can you describe how those static limits are set?
So they're I believe it's just an inverter setting.
Okay, so when the customer applies, do they specify a specific limit or at something?
I think they're outlined in the manual.
Okay. And does the company have any plans to expand the use of static limits to other types of use cases, for example, EV charging installations?
I don't know.
Would the company consider committing to providing some form of standard process and guidance for customers regarding static limits? I know you said it's kind of described in the manual, but some other sort of process or guidance.
So, and can you repeat the question, please?
Yeah. Would the company consider, actually, sorry, let me ask a different question first. Do you think that the opportunity to use static limits is clear to customers from the manual that you mentioned earlier? Or do you think that's kind of difficult for customers to understand that opportunity?
Yeah, I mean, most of our applications are submitted by developers and not customers, just due to the complexity of what's being requested with the application. So just all the technical details there.
And so do you think developers understand that there is this opportunity for static limits from the information that's currently provided?
Yes, this was something that was communicated at the beginning of the year.
Okay. Do you think that there's any kind of process or informational opportunities for the company to make this the static limit opportunity more understandable and accessible to developers and other customers?
Yes, we have reached out a few times. If we could, one way to provide more information when there are questions is through office hours. You know, we could provide something like that.
Okay. And do you think that's something the company would be willing to commit to doing to help increase access to the static limit opportunity?
Again, it's there, so, but certainly we can help clarify. Yes.
Thank you. And you said earlier that the company is expecting to have the grid DERMS implementation going for community solar or solar gardens by Q1 2026, right?
Yes.
And do you have a sense of when the grid DERMS will be available for other use cases?
Yes, we're planning to test the limited deployment of 2 other use cases at the same time, the testing piece.
And what are those 2 other use cases?
Dispatchable DG, dispatchable distributed generation, and flexible energization for large EV loads.
And following that, does the company have plans to expand the approach to flexible interconnection and permit a broader range of use cases?
I think that the company hopes to gain experience deploying these select use cases while looking at other future opportunities as well. So yes.
And did you review the cross-answer testimony of AEU's witness, Edward Burgess?
Yes.
Okay. And I believe I asked these questions to Mr. Pollack, and he asked me to ask you. Do you recall the example that Mr. Burgess provided of California's approach to flexible interconnection, which includes static limited generation profiles, or LGPs?
I might want to see his reference.
Certainly. Ms. Federico, could we please pull up hearing exhibit 2103? And we'll go to page 19, please. And Ms. Chacon, if you could look at lines approximately 3 to 8 or so, that question there that's in the middle of the page.
Yes.
And Mr. Burgess suggested that the limited generation profile program, DERs can voluntarily schedule reduced generation output from their projects at specified times to avoid paying for infrastructure upgrades, right?
Well, he says expand system carrying capacity, so.
Okay, thank you. And do you see Mr. Burgess's testimony that the LGP program is one that could be readily available and implemented quickly in Colorado?
Yes.
By your understanding, does the implementation of the LGP, which utilizes a static flexible interconnection, require utilization of a grid terms?
Right, that's what I provided in my rebuttal testimony.
Okay. So could the company commit to a process to consider the limited generation profiles approach as a flexible interconnection approach in Colorado?
Can you repeat the question, please?
Sure. Could the company commit to a process to consider the limited generation profile approach as a flexible interconnection approach in Colorado?
The company could commit to looking into this.
Okay, and by looking into this, what does that mean from the company's perspective?
What was the word you used?
I said a process to consider.
Yeah, we would support a process to consider.
Thank you very much, Ms. Chacon. Those are all my questions for you.
Thank you, Ms. Judkins. I have IREC 30 minutes, and it's about a little before 10:10.
Good morning, Chair. My name is Seth Goldman. I'm an attorney with Schumahali and Weinberger, representing IREC in this proceeding. And I would like to waive my cross of Ms. Chacon. I think the previous cross-examinations covered the territory that IREC was looking to cover. Thank you.
Thank you. I have Tesla, 25 minutes. Ms. Mandel.
Thank you, Chair. I'm in a little bit of the same position that Mr. Goldman just talked about the previous crosses covering a lot of the content that I was going to cover.
Would you like a 5-minute break, Ms. Mandel? Would that potentially speed things up?
No, I think I'm gonna proceed, but it's gonna be limited. Was my longer way of saying I'm gonna take a lot less time.
All right, thank you.
Good morning, Ms. Chacon. It's nice to see you.
Nice to see you.
For the record, Victoria Mandel representing Tesla in this proceeding. So as I said, a lot of the content I was gonna discuss with you has already been covered, but I'd like to talk a little bit about sort of the no pun intended disconnect between the timing that it takes to construct charging facilities, either public or, for example, private large facilities for fleet charging, for example, semis. And so I can go to Mr. Ehrlich for Tesla. I can go to his testimony, but we can also I can ask you generally, are you familiar with sort of that disconnect in timing, sort of weeks to build versus years to sometimes construct on the utility side. Are you familiar with that?
For large loads, yes.
And I think, have you been present during the hearing and listened to the other witnesses testify?
For the most part.
And I've discussed with other witnesses, Mr. Ehrlich's testimony that that Tesla is experiencing acute capacity constraints, especially in the Denver metro area. Are you familiar with that as well?
With what was in the testimony on that topic?
Yes.
Yeah, I might want to see that.
Okay, let's go to the cross answer testimony of Mr. Ehrlich, please. That's hearing exhibit 1601, page 6, lines 7 through 9.
Okay.
And can you, okay, so now you're familiar with his testimony that Tesla is experiencing acute capacity constraints in their efforts to further transportation electrification in Colorado. So my question is, well, I'll ask you one more foundation question. Were you also present and did you hear Ms. McDermott testify that in terms of capacity limitations on feeders and those feeders reaching their limitations, she said that those limitations, capacity constraints, amounted to several minutes across several days on feeders. Do you recall that as well?
Yeah, well, I guess I'm wondering about the term acute capacity constraints, if that, from Mr. Ehrlich's point of view, means that there's an upgrade that needs to be made to connect a project, I guess. I didn't know if that was his like local, or if he was, I guess I still thinking about what that means, but I guess.
Okay. Would it be helpful? I believe later in the testimony, he provides a map of where Tesla is being told by the company that it is not able to connect. Tesla's is not able to interconnect Tesla. I think it's a few pages lower. There's a map. If we wouldn't mind scrolling down.
Yeah, and I'm just wondering if it's not able to connect or not able to connect without an upgrade.
Yeah, I'm sorry, I don't know that either. And I'm sorry, I don't know where the map is in. I think it might be in the cross answer. There's a map that shows where Tesla has requested capacity and has been told that there are constraints that do not allow Tesla to interconnect.
Yeah, and I guess what I'm trying to understand is whether it's connect without making some type of system change, or never connect. I assume it's the latter, so.
Yeah, I'm sorry, I don't know more detail about that. Yeah, I don't know if that assumption is correct or not, Mr. Chacon. I'll go back to the question I want to get to, aside from the foundational questions I've raised. And that is, can you agree with me that aside from the several minutes across several days where feeders are reaching their capacity constraints, that there is significant room for capacity during those times when the feeders are not, let's say, at peak, that capacity is there and is available. Can you agree with me on that?
I believe that there could be capacity during non-peak periods.
And can you agree with me that flexible interconnection has the potential to allow customers such as Tesla to interconnect to the system more quickly to use that available capacity?
I believe so.
And can you agree with me that the use of that available capacity would result in cost savings for ratepayers?
Well, the infrastructure is already there, so maybe not in that case, I guess.
Can you agree with me that allowing the use of that available capacity more quickly would further state policy goals such as transportation electrification?
Yes, I believe so.
And would it also further state policy goals such as reduced emissions?
I'm not sure what the state policy goals are on the emissions and EVs.
Can you agree with me that EVs emit less pollutants than regular combustion engines in cars?
Some pollutants, yes.
No further questions. Thank you, Chair.
Thank you, Ms. Mandel. Commissioner Gellman, questions for Ms. Chacon?
Good morning. I don't have any questions. Thanks.
Commissioner Plant.
Hi, good morning, Ms. Chacon.
Good morning.
I'm still a little stuck on one of the lines of question I think Ms. Kutzer was discussing with you, and I'm really where I'm stuck is on the statutory language in 218. And if you want to bring up 218 and go to page 8, it seems as though the company is proposing that instead of flexible interconnection, they would provide this phased interconnection and energization agreement. But on page 8 of Senate Bill 218, if you could bring that up on the screen, it clearly says that the customer is required to be participating in an interconnection tariff. It says in exchange for the customer participating in a qualified utilities interconnection tariff. So I'm just wondering, I mean, I feel like the statute is pretty clear that the company needs to file an interconnection tariff, that they can have an interconnection agreement with a customer as long as that customer is participating in that tariff. But the company is proposing not to file an interconnection tariff, and it seems to me that that would be in conflict with the statute. Is that your understanding as well?
I mean, I guess I am not a legal or regulatory expert, so I'm not sure.
You and me both. I'm a geologist, but you know, it's a legal world and we all live in it, I guess. But I mean, it's just, I mean, it's English, right? I know that lawyers think they have their own language, but it's really just English. And it says that in order to be in a phased interconnection agreement, the customer is it's in exchange for the customer participating in a tariff, and the company's saying we want you to be in an agreement, but we're not going to provide a tariff, and that just doesn't seem to make sense to me. I don't know what your take is on that, I guess.
Yeah, I think it's just that, you know, that the term "or" is what I think the company felt would the operable language, whether it's an interconnection agreement or a tariff.
Yeah, I get that "or," but I don't think that really applies here. This paragraph doesn't have an "or," except for within the quotes. I think the language that you're talking about is where it says that it talks about the flexible interconnection or energy tariff, and you know that a customer is in that or an agreement, but the agreement is based on an exchange for agreeing to be a part of the tariff, and so I think the company's hanging their hat on an "or" that doesn't really apply here. The definition is pretty plain. So I mean, I guess all I'm saying is I don't get how you can not provide a tariff and be in compliance with the statute. And I don't know that you have anything to add to that. I just that's kind of where I'm stuck. And I don't know if you have any comments on that or
no, I don't have much to add on that.
Okay, that's all the questions I had, Mr. Chair.
I had forgotten you were a geologist. I don't have any questions. Mr. Larson, redirect.
Thank you, Mr. Chair. Good morning again, Ms. Chacon.
Good morning.
So notwithstanding the legal pieces of, you know, the agreement versus the tariff with respect to flexible interconnection, can you talk a little bit about, you know, why the company at this juncture prefers an agreement as it relates to flexible interconnection as opposed to a tariff?
I mean, the company just felt that it would provide more flexibility as we go through this new process, to make adjustments if needed by either the developer or the customer.
Okay. And from the discussion with Ms. Kutzer, the company that agreement is pending, is in the company's currently pending res plan, right?
Yeah, that's correct.
And I'm not asking you for a legal conclusion, but are you aware of any specific statutory deadline that applies to the filing of such agreement?
No.
So there was some discussion with Ms. Kutzer and Ms. Judkins as well about demonstration projects, and you looked at the pivot one in particular. Can you just describe for the record some of the activity that the company's undertaking right now, specifically at assets that are owned by the company? While we start there, and then we'll follow up.
Yes, we're looking at kind of a mock flexible interconnection demonstration at one of our company facilities called Arapahoe, which is an actual solar garden. And we're putting in the equipment that would allow the monitoring and control of the PV system, so that we can have experience with sending signals to this device and seeing how the PV system responds to it. And it's the same type of plant controller that the solar garden developers would use.
Thank you. And can you talk a little bit about how those activities and the testing that the company's doing can then flow out into, further potentially more expansive programming agreements, activity by the company?
Yes, it's important for us to gain that operational experience before a larger deployment. So it gives us the opportunity to demonstrate that and tie that in with our company systems, including the limited deployment DERMS that we're working on.
Okay, thank you. And you had some discussion with Ms. Kutzer as well about the status of the pivot contract. You recall that?
Yes.
And if I can summarize what I heard, and then you can expound on it, but is the situation that the engineering and project scoping is ongoing and that has taken precedence over the contract, or can you just sort of describe the current situation there?
Yes. Well, we've been working with Pivot on identifying which project they would be interested in moving forward with, so that we can start to gain some experience with the more sophisticated flexible interconnection study that is needed to help identify the potential curtailment that might be needed during a grid constraint.
Thank you. And you also had an exchange with Ms. Judkins about PG&E's SAVE, SAVE program. Do you recall that?
Yes.
And just a general question, do smart panels increase the capacity of the grid?
No.
Okay. And would it surprise you if Mr. Pollack talked a little bit about the PG&E program in his rebuttal testimony, specific to some of the funding sources for that?
No.
And I think, Ms. Chacon, with that, that's all I have. Thank you, Mr. Chair.
Ms. Chacon, you may be excused. Why don't we take a 10-minute break till 10:40 and come back with Mr. Marion. Thanks. Mr. Marion, are you out there?
I am indeed. It's good to meet you, Chair.
Likewise, can you hold up your right hand? You swear to tell the truth, the whole truth, and nothing but the truth. You can put your hand down. Is anybody with you or communicating with you in any way?
No.
If that changes, will you let us know?
I will.
Back to you, Mr. Simpson. Oh, you're muted.
Good afternoon, Mr. Marion. Can you state and spell your name for the record, please?
My name is Sean Marion, Shaun Marion.
And are you the same Sean Marion that submitted rebuttal testimony in this proceeding?
Yes, I am.
And you did not submit any direct testimony in this proceeding, correct?
Correct.
And if you were asked the same questions today, would you have the same answers?
I would.
And I believe your rebuttal testimony has already been entered into the record as hearing exhibit 130. And so with that, the witness is available for cross.
Let's see. I have ACE 45 minutes. Mr. Schlesinger, you're muted, and it's 10:40.
Thank you, and good morning. Good morning, Mr. Marion. Nice to meet you.
Good morning.
My name is Jake Schlesinger. I'm here representing today ACE, or the Associations for Clean Energy, which is a coalition of a number of solar and storage trade associations, along with other clean energy technologies. I'm going to ask you questions today about your rebuttal testimony, and primarily your response to recommendations from both ACE and IREC who both recommend that the company be required to make all hosting capacity data available without requiring a person seeking access to execute a non-disclosure agreement. You're familiar with that general issue, right?
Yes, I am familiar generally, yes.
Okay, great. And I believe you are also familiar with the settlement that resolved the last DSP proceeding, 22A-0189E, at least as it pertains to this issue, correct?
Generally, yes.
Okay. And would you agree with me that part of that settlement allowed the company to use an NDA to access the secure web portal for hosting capacity?
Yes, I believe that was the agreement.
Okay. And you understand that at least some of the parties that make up ACE joined that settlement agreement, right?
I don't know that specifically, but that would make sense.
Sure. Okay. Do you understand that the settlement agreement did not specify the form of NDA that was to be used?
I do not know that. Full disclosure, I've been here 13 months. That happened prior to me coming here, so I'm not aware of that specifically, no.
Okay. Well, we can pull it up if that would be helpful and take a look, but are you...
I take your word for it.
Okay, fair enough. Would you agree with me that the form of the NDA, are you familiar with the NDA that the company currently requires customers to, or users to execute to access the hosting capacity?
Generally, yeah. I've read it, yes. Not an expert, but I'm familiar with it.
Okay. And would you agree that that NDA is significantly different than the NDA that parties to a commission proceeding are often asked to sign?
I can't agree to that, but that's only because I'm not familiar with the difference between the two. So that's the reason I can't agree to that.
Okay. Well, if we can assume that's true for the purposes of this question, well, let me back up for 1 second. Are you aware that ACE witness, Joan White, whose testimony you responded to, specifically detailed some of the provisions within the company's NDA, which she found to be problematic?
I am, yes.
Okay. And do you recall her stating within that testimony that it was different, significantly different than the form of the NDA that the parties to a commission proceeding typically sign?
Something to that effect, yes.
Okay. All right. So given that understanding, and given Miss White's testimony regarding specific objections to specific provisions, do you think that ACE would be objecting in this proceeding had the company used an NDA that's similar to the NDA parties are used to signing?
I don't know that I could answer that. I'm not in their shoes. I would assume so, I guess, but I don't know. I wouldn't know for sure.
Okay, well, based of your review of Ms. White's testimony, does it make sense that if the company had used a standard NDA that similar to the commission NDA, that it's likely some parties at least wouldn't be objecting?
Objection calls for speculation.
Overrule.
Yes, sorry. Could you I understood your question, but I've lost my train of thought. Could you please repeat that question for me?
Sure. Just given our discussion right now, do you think it's likely that had the company used or proposed an NDA that was similar to the NDA parties to a commission proceeding are used to signing, that there would have been less objection?
That would generally make sense to me, yes.
Okay. Are you also familiar with the term from the last settlement agreement, which noted that the issue of data security was an evolving issue and that parties could take a different position than the settlement agreement on that issue in future proceedings?
I'm aware of that, yes.
Okay. So given that term and given the fact that the company is using a different NDA than the standard commission NDA, it's not surprising that parties to this proceeding are objecting to that settlement, are objecting even given that settlement term, right?
Yeah, I think so. I mean, if we had watered down the NDA, I guess we would have had more people agree to it. So I guess the corollary, the opposite of that would likely be true.
Okay, fair enough. And so now the parties primarily recommend that no NDA be required, right?
That's what I've read, yes.
Okay. But you argue that the commission should continue to allow the use of the NDA, but if the commission is inclined otherwise, then the company strongly suggests that such an evaluation is most appropriately conducted through a thorough and thoughtful manner outside of the context of this proceeding. That was your recommendation, right?
In essence, that was my recommendation, yes.
Okay. And in a response to discovery, which you sponsored, where we asked you why, basically, why should this be in another proceeding? You responded that the DSP proceeding is focused on distribution system planning, and much of the testimony and focus is on non-security topics. You go on to state, it also does not include all the stakeholders that might be interested in security issues and does not involve input from security agencies or persons with security responsibilities besides Mr. Marion himself. Did I state your response accurately?
I don't see it, but that generally, yes, that is what I said. And I take your word, that's on the document.
Okay, yeah, and I'm just trying to be efficient here instead of pulling up.
No issues. Yep, no issues with that.
If it doesn't sound right, I'm happy to do it, but glad it does. Okay. Are you at all familiar with the Commission's DSP rules regarding the web portal and access to the web portal?
In any way familiar, yes. I wouldn't say that I have complete familiarity.
Okay, well, are you familiar with the fact that such a rule exists within the Commission's distribution system planning rules?
I am familiar that it exists, yes.
And exists specifically within the section of the rules on distribution system planning?
I'm not aware of that, no, but I will take your word that that's what it is.
Okay, thank you. So assuming that you're taking my word that that's what it is, wouldn't the DSP proceeding be the proper place to consider whether or not the company is complying with the DSP rules?
Yeah, honestly, Mr. Schlesinger, I don't know that I could answer that, and I'm not trying to be obtuse. I don't understand the flow and the process well enough to accurately answer that.
Okay, fair enough. Are you aware that the Commission conducted a rulemaking proceeding prior to implementing its DSP rules? and that proceeding was 20R-0516E.
Not off the number, no. I'm familiar with rulemaking. The number throws me off a bit, but I don't know that you showing to me will change that much. If you're telling me that's the case, I'm happy to take your word that that's true.
Well, you know what? Let's go ahead and pull up a discovery response where I believe you referenced that rulemaking by number. And I'm sorry, just need 1 second to get the right number. I think it's 914. Ms. Federico wants to start there while I confirm. Yes. Can you scroll down to the bottom of that? And so I think the numbering got a little messed up here, but if you see your response to D there, the company conducted a benchmarking analysis of hosting capacity map disclosure of 50 utilities in 2020 as part of the DSP rulemaking proceeding, the results of which were provided in 20R-0546E. Okay, so we can pull that down. So now based on, and you were the sponsor of that discovery response, right?
The response, yes.
Okay. And so so you are aware that there was a rulemaking proceeding prior to issuing those rules, and that
yes.
was the proceeding number.
Yes.
Okay, great. Are you also aware that prior to issuing the proposed rules in that 20R-0516E docket, the commission also held a miscellaneous proceeding to discuss the contents of those rules?
That's not ringing a bell. The term miscellaneous is what's throwing me off here. So I don't recall, honestly.
Okay, fair enough. Yeah, miscellaneous dockets at the commission are non-litigated proceedings. This one was proceeding 19M-0670E.
Okay.
And it was considered a pre-rulemaking docket. So are you aware of that? Does that sound familiar?
It does sound familiar, yes.
Okay. All right. And are you aware that the topic of data security, specifically regarding access to hosting capacity information, was contemplated in both of those proceedings?
Generally, yes, I'm aware of that.
Okay. And are you aware that any rulemaking that the commission conducts must be noticed via the Secretary of State of Colorado?
No, I am not aware of that, no.
Okay. Are you aware of the fact that the commission is required to notice any proposed rulemaking as just as a general matter and allow public comment?
It makes sense to me, but no, I'm not generally aware of that. Full disclosure, I mean, I've been in security for almost 30 years, but I'm relatively new to this industry. So these types of things have not been something I've traditionally taken part in.
Okay. Well, if I was to represent to you that is a standard legal requirement in administrative law, that the commission must notice and allow any interested party to comment, wouldn't you agree that stakeholders that might be interested in security issues had an opportunity to comment on these issues at that time?
With a caveat, yes. The world that we're talking about here is fairly complex. So I would hope that if people were commenting, there were people that had, experience or expertise in this area and not just pontificating. But if they did, then yeah, I would think that would make sense.
Okay. Well, and the company commented in the rulemaking proceeding, at least, right? You know that.
Yes.
And so does the company have expertise on data security issues as it relates to hosting capacity information?
Sure hope so.
Okay.
That's a yes, by the way.
Yes, understood. Thank you. Are you aware that the specific issue of whether a non-disclosure agreement should be required to access hosting capacity information was actually debated in that 2020 rulemaking proceeding?
I am aware that it was debated. I'm not aware of every aspect of the debate, but I am aware that it was debated.
Okay. And actually, sorry, let's pull up that same 914 that we just had up, if you would please, Ms. Feder. I'm not sure who's driving today, but thank you. So again, referring to that part D, you did reference the company's comments and a benchmarking study on hosting capacity map data disclosure. So you are aware then that the company commented specifically on that issue, right?
Yes, I'm aware they commented, yeah.
Okay. And I'm sorry, while we have this up, can we just go ahead and move for the admission of 914 here?
Any objection, Mr. Simpson?
No objections.
So moved.
Okay, thank you. And we can pull that down again. And are you aware that the recommended decision in that proceeding, which was authored by Commissioner Gilman, explicitly denied the proposal to utilize an NDA for hosting?
I'm aware of that, yes.
You are aware of that, okay. And instead, the commission adopted Rule 3541B regarding data security and access to hosting capacity.
That is not ringing a bell. I read a lot of data and documents. That specific one does not ring a bell.
Okay. Whoever's driving, can we please pull up the commission's electric rules, which I did put in box for convenience?
Do you have a number for that?
I didn't mark it as a hearing exhibit since it's a commission rule. I just put it in as.
Oh, I see it. No worries.
And if we could go to PDF page 111. And if we could scroll down to 3541B, so we can see the whole thing there. Yeah, perfectly. Perfect, yeah. Okay, so let's just take a look at this rule. This states that the utility may only deny access to its web portal if visitors and/or registrants violate the terms of service or other agreed upon terms of access. And to ensure the appropriate level of protection of sensitive information, the utility may require visitors to the web portal to take actions, including, and two things are listed here. One is requiring visitors to acknowledge terms of service associated with its use, provided those terms do not preclude academic or public policy purposes. And two, establishing registration processes, including the creation of username and password and/or the use of multi-factor authentication for access to sensitive information. So going back to the question that I asked you before, would you agree with me that instead of allowing this rule to contemplate non-disclosure agreements, it became what it is that we just read?
Well, bear with me as I process this. So no, again, everybody says this. I'm no lawyer, so I'll do my best to interpret. But if I look at the statement of violate the service or agreed upon terms, and the statement requiring visitors to acknowledge terms of service, and then establishing a registration process, I don't see anywhere in there where it explicitly denies an NDA. I agree that the things it does ask for are valid, but I don't see, at least in that verbiage, where it would deny the use of an NDA.
Okay, but the recommended decision that went along with the issuance of these rules did explicitly deny the NDA, right? And
yes, as I've been told, it has, yes.
And it declined to include that term in this rule.
Okay, yeah, I don't have the verbiage in front of me, but I've seen it before, and that would make sense.
Okay, and so just to be clear, of the two actions that the utility is explicitly allowed to take, neither of them is an NDA, right?
I agree with the latter part based on the verbiage. I don't think this precludes us from taking additional actions, but I believe based on the verbiage we just recently discussed around the NDA, that yes, that verbiage would preclude that, in my opinion.
Okay. Okay, we can take this down. Thank you. In your rebuttal testimony, you state that NDAs are a relatively common tool in the industry that companies and institutions use to protect data. Do you recall that?
I do.
Okay. And I think you just stated a little while ago that you've really only been working in the utility industry for about 13 months. Is that right?
Roughly.
And how much of your time during that well, I'm sorry, backing up. You never worked in the electric utility prior to your recent 13-month tenure with Excel?
No.
Okay. And in your 13 months, how much time do you spend working on NDAs?
Well, I don't work on NDAs in my role. I do sign them. In fact, I signed one this morning. Irrelevant of this, so I do sign them fairly regularly. And I would say that even outside of this industry, if I had to swag, I've probably signed several hundred NDAs in my career.
Right, but not within the electric utility industry, right?
Without having the data in front of me and subject to validation, I would probably say I've easily signed upwards of 20 NDAs, 10 to 15 NDAs since I've been here. So it's common. To your question, how much time do I spend? I mean, I talked to the attorneys here and they give me feedback and then I sign. So it's not a lot of time to process it, but I do sign them on a regular basis.
Okay. And in your role as, is it Chief Security Officer?
Yes.
In your role as Chief Security Officer, during the last 13 months, have you ever suggested to the company that it use an NDA for security reasons in another context?
Absolutely, yes.
Okay. Did you provide any input on the specific form of the NDA that the company uses to protect the secure web portal?
I did not know.
And you didn't because that NDA predates your tenure with the company, right?
That's correct.
Okay. And when asked in discovery, and actually let's pull this up because I'm going to move to admit this one. This is hearing exhibit 919 in our box.com. Thank you. And if we could just scroll down a little bit to the middle of the page there, perfect. When asked in this discovery response in part A there, whether the security team, Mr. Marion, his predecessors, or security services team were the first team in the company that proposed to keep certain HCA data protected under the NDA, you responded that decisions regarding whether and when to use a non-disclosure agreement are made collaboratively by multiple organizations within Xcel Energy, including in-house and external counsel, correct?
Correct.
Can you tell me what other parts of the company weighed in on the original decision on whether or not to use an NDA?
With respect to the HCA data?
Correct.
I cannot say specifically. I wasn't here for that decision.
Okay. Do you know generally who the inside and outside attorneys take their direction from at Xcel?
No, I do not. I mean, it varies depending on the topic and the subject and so forth.
Okay, but can you at least agree with me based on this response that it's multiple parts of the organization that collaboratively worked on this, that it wasn't just a security decision? It didn't just come from the security team?
That would be speculative. If it were me here now, then yes, that is how it would proceed. I was not here for that specific one. I could only assume that it would proceed like the other ones would.
Okay, but in this response, you say that it's multiple, collaboratively by multiple organizations within Xcel Energy. You said you didn't know which other organizations within Xcel Energy were part of that, but it wasn't just the security team, right?
I apologize. I misunderstood your question. The way you've phrased that, yes, I wouldn't know specifically who, no, but yes, it would have been other organizations and other people.
Okay. I'd like to move for the admission of this exhibit 919.
Any objection?
No objections, but I do note that there was a privilege objection provided here, so further discussion of this would be subject to us being able to make a privilege.
With that proviso, so admitted.
Thank you. Mr. Marion, did you provide any examples of similar hosting capacity NDAs in your testimony from other utilities outside of public service?
No, I don't believe so.
Do you know if any other public service witness did?
I don't know. No, I don't know.
Oh, and I'm sorry, we can pull this down. Do you know whether any other public utility in the United States requires an NDA to access hosting capacity information?
No, I don't know that off the top of my head, no.
Okay. But in your testimony, you did claim that the company considers what data other utilities make available. Do you recall that?
I do.
Okay. Did you consult with any other utilities in preparing your testimony for this proceeding and in formulating your recommendations regarding the use of an NDA for hosting capacity?
I did not, no.
Okay. And we talked a little bit about, your response to 914 earlier, where you referenced a benchmarking study from the 22 rulemaking. Do you recall that?
I do.
Did you conduct any new benchmarking studies regarding NDA data portal user access at other utilities, or is the 2020 benchmarking study the most recent that the company has?
Kind of a nuanced answer because you've got a multi-part question there. I did not conduct any additional benchmarking, and to my knowledge, none has been conducted since I've been here. Prior to that, I can't say for certain.
Okay. And in 914, you referenced the company's comments in that 2020 rulemaking and that benchmarking study, which was an attachment, right?
Correct.
Okay, I'd like to pull up each of those documents, starting with what's been marked as 915.
I'm having trouble opening that one. Just give me a minute to try to.
Thank you. Okay, and if we could scroll down to page 25, please. And just scroll down a little bit more. So we're looking at that part. Actually up a little further more. Mr. Marion, if you could just take a quick look at this page and confirm for me that these are the company's comments that you are referring to in that discovery request that references the attachment B, the benchmarking study.
Yes.
Okay. I'd like to move to admit hearing exhibit 915.
Mr. Simpson?
No objection.
Okay. And then we can pull this one down and let's pull up the attachment, which is marked as hearing exhibit 916. And that's the attachment B, the benchmarking study itself. If we could zoom in a little bit on that, I think we can ignore the far right column in favor of the others. Okay, so Mr. Marion, is this the benchmarking study you referred to?
Yes, I believe so.
Okay, before I forget, I'd like to move to admit this exhibit 916.
Mr. Simpson?
No objections.
Okay. Mr. Marion, can you point to any of the utilities on this list that require an NDA to access hosting capacity?
Well, as stated before, I'm not aware of any that do or don't. I don't track who has NDAs. I don't know if it's supposed to be on this page. If it is, could you point me where I would find it?
I don't believe that it is on this page. Let's talk about what is on the page. The hosting capacity map availability column has a number of, the overall classification there. Well, sorry, let's start with hosting capacity map availability. Has a number of designations depending on the utility. And I believe these are the 50 largest utilities in the US at the time. Is that your understanding?
Yes.
Okay. So for the first one, PG&E, Pacific Gas and Electric, the hosting capacity map availability is username and password. So what do you think that means?
With respect to that one, I would take it at its word, username and password.
So a user would need to create a username and a password in order to access the hosting capacity maps.
At a minimum, yeah, I don't know if they require multi-factor or other things above and beyond that. I can't see that from this here, but at a minimum, I would say, yeah, they require username and password.
Okay. And then Southern California Edison says public. So that would indicate that they don't require anything. It's just available to anyone who can access it, right?
That's how I would read that, yes.
And then Florida Light or Florida Power and Light Company says not available. So I think I would take that to mean that they don't have a hosting capacity map or they don't have that data available. Does that sound right?
I would take that to mean they don't provide it. They might have it, but they don't provide it.
Okay.
But they may not have it. I don't know.
Okay. And then the next column, overall classification, I see basically three main classifications, restricted, detailed public, well, I guess four classifications, not available, high level public. Am I missing any?
At a quick glance, I don't believe so.
Okay. And if we could scroll down to the bottom of this. There we go. And maybe zoom in a little bit so we can read that footnote. This footnote sort of defines what each of those terms means: detailed public, high level public, restricted. You see that?
I do.
Okay. And so restricted means hosting capacity maps that at a minimum require creation of a username and password. You agree?
I agree. That's what it says. Yes.
Okay. But not necessarily an NDA, right?
Well, it says at a minimum it requires that, so it could include an NDA. I would throw in one thing that.
Well, I'm sorry. Before you do, I'd like to make sure that you answer my question. My question is, it doesn't necessarily require an NDA, right?
Yeah, that's fair. It doesn't necessarily require an NDA.
Okay. And I'm sorry, I'm going to finish with my questions, and if you have something you want to talk about with your attorney on redirect, that's fine. And I think you said before that you haven't done any research prior to this proceeding. So this hasn't been updated since 2020. Is that right?
To my knowledge, no.
Okay. So you didn't make sure before this proceeding that the utilities, and actually, I'm sorry, if we could scroll up a little bit, I want to count the number of utilities here that say restricted. So if we could kind of go down, there's PG&E, that's one. There's Consolidated Edison, that's two. And you tell me if I'm missing one. There's Niagara Mohawk Power Company, that's three.
Objection, the witness is testifying. Also, there is a summary in hearing exhibit 915 that provides all this information.
Okay. Well,
I have to say, you've made your point, Mr. Schlesinger, and I don't know that we need to take hearing time to go through this one by one.
That's totally fine. I will summarize. Would it surprise you, Mr. Marion, if there were 7 on this list that were marked as restricted? Does that sound right to you?
Roughly, yes.
Okay. And if I were to tell you that I checked the websites for each of those 7, looking for restrictions, and was able to publicly access hosting capacity maps as early as this week on at least 5 of those, would that surprise you?
You seem like a reputable person. That wouldn't surprise me if you did that.
Okay.
Are you going to provide evidence of that, Mr. Schlesinger?
No, it was just a question.
Okay.
Anybody can go to those websites and check for themselves. So you testified earlier that you're not aware of any utility in the United States that requires an NDA to access hosting capacity. Given your testimony on that, would you at least agree with me that NDAs for hosting capacity are not common in the electric utility industry?
Honestly, I don't have enough information to say that. I would have to go to each of these and confirm that. Does it make sense based on the data I see on my screen? Generally, yes, but I don't have data to confirm for sure.
Okay, thank you. That is all the questions I have.
Thank you, Mr. Schlesinger. AEU, 15 minutes and it's 11:15.
Thank you, Chair. Good morning, Mr. Marion.
Good morning.
My name is Sarah Judkins, and I'm representing Advanced Energy United in this proceeding. And like Mr. Schlesinger, I'd like to focus my questions this morning on your recommendations related to data security for the hosting capacity information. So he covered some of the questions I wanted to ask you, but let's start with, in your rebuttal testimony, you stated that the company is concerned that a high impact attack could be planned using HCA data, right?
Correct.
Are you aware of any studies or reports that, are you aware of any studies or reports that document high impact attacks on the distribution system that have been enabled by access to HCA data?
That would be highly irregular. No, I'm not aware of any.
Are you aware of any reports or studies on best practices for distribution system security that recommend not providing public access to HCA data?
I understand what you're asking, but I disagree with the premise of the question that you're asking. And what I presume is that you believe that would be a normal thing. Typically, they would talk about how to protect various parts of the grid or sensitive systems or sensitive data, but it wouldn't go into individual pieces of sensitive data. So am I aware of any reports? No, but that would be the same for any other type of sensitive information.
Sorry, maybe I'm a little confused by your answer. Did you just say that the reports would go into detail as to how to protect specific pieces of information?
The opposite. They would talk about data protection strategies, policies, standards, technologies, but rarely, unless it's called out in regulation like HIPAA, PII, things like that, it doesn't get down into specific data points. Rather, it talks about how you protect sensitive data in general and the things you do to keep it safe.
Okay, so just to be clear, the answer to my question is no, right? That there are not any best practices for distribution system security that recommend not providing access to HCA data. Understanding your objection to the premise.
Yeah, not that I am personally aware of, no.
Has public service conducted any studies to understand the risks to the distribution system associated with access to HCA data?
We conducted studies. Could you clarify what do you mean by study?
Or have you conducted any, study information gathering to understand the risks to your distribution system associated with access to HCA data?
I understand your question. Recently, yes. Since I've been here, yes. Prior to that, not that I was involved in, no, but recently, yes.
Can you describe those studies?
Sure. So a lot of it was tied, as you can probably understand, to the discussion we're having now. And a lot of it was to familiarize myself personally with, how the data could be used, so on and so forth. So we did have a number of discussions internally with our own teams to go through the possible scenarios of how data like that could be used, and what an attacker might want that for. And if that is what you mean by a study, we did go through that to evaluate what we believe the relative risk would be to our systems if that data were to be exposed.
But that information isn't included in your rebuttal testimony, is it?
It's the premise for a lot of my rebuttal, but it is not included in the rebuttal, no.
Can you provide any examples of high impact attacks on the distribution system that were enabled by access to HCA data?
Just one point. To the extent we may have confidential information or classified information, Mr. Marion, I just want to put parties on record or on notice that we may have to close the hearing. Also, we can recall Ms. McDermott, if anybody would like to cross-examine her on the actual data information and issues bad actors can do.
Thank you very much. I did ask these questions of Ms. McDermott, and she pointed me to Mr. Marion. So you are answering them, so which I appreciate. Thank you.
Ms. Judge, could you repeat your last question? Yes, please.
Yeah, certainly. Can you provide any examples of high impact attacks on the distribution system that were enabled by access to HCA data?
No.
Turning briefly now to the NDA, noting you had an extensive conversation with Mr. Schlesinger about the NDA. You discussed with him that in your rebuttal testimony, you state that NDAs are a commonly used tool, right?
Correct.
And you also stated with Mr. Schlesinger earlier that you reviewed the specific terms of the company's unique NDA required to access the secure web portal, right?
I have reviewed it, yes.
Are you familiar with the provision that could subject the signatory to substantial liability even for an inadvertent breach?
I'm not. I've read it, yes. I wouldn't say that I'm familiar with it, but I have read it, yes. Highly familiar. I'm just the details I'm a bit scant on.
All right, that's fine. We can pull it up. I believe it's in the record, hearing exhibit 801, attachment MSM.5. This is IREC's witness testimony, please. If we could take a look at paragraph 6, please. And Mr. Marion, is that zoomed in enough for you to see?
It is. Thank you.
Right. So here we see that requester acknowledges that the extent of damages in the event of breach of any provision in this confidentiality agreement would be difficult or impossible to ascertain, and that there would be no adequate remedy at law in event of such a breach. Therefore, the requester therefore agrees that if or its authorized personnel breach any provision of this confidentiality, Xcel Energy would be entitled to seek specific performance or injunctive or other equitable remedies, and so on, right? Did I read that correctly?
You did for the portion you read, yes.
And there is no limit on liability for an inadvertent breach in this paragraph, is there?
That's how I read that, yes.
Okay. Recognizing that you're fairly new to the electric utility industry, have you ever seen such a broad liability provision in a similar utility data sharing context?
Yeah, yes. If I understand the question correctly, yes, I have. I have seen provisions like this when we share sensitive information with key partners and some suppliers. Whether it's word for word the same, I don't know, but in essence, with respect to liability, there are some that are similar.
And are those partners, I forget the exact language used, or key customers, maybe you said,
Key suppliers.
key suppliers, thank you. Are those sophisticated entities or are they kind of individual customers of the company?
Sophisticated, these big companies.
Thank you. And for the secure web portal, that, it might be developers or companies that are seeking to access this information, but it also could be individual customers of the company, right?
I don't know that I could answer that. My assumption was that it was big companies, developers, or whatnot, but I don't know if an individual customer would use this or not.
Sorry, one second, just reviewing my notes.
No worries.
Could we look at paragraph 10, please? Thank you very much. And do you see, I'm sorry, I want to make sure I'm pointing you to the exact part of this paragraph I want to discuss. Let's start at the beginning. So the requester must retain confidential information in a secure place that prevents unauthorized access, right?
Correct, I read that.
And then it states the requester shall cause the authorized personnel to use at least the same degree of care as requester would use to protect its own confidential information of like character itself and cause its authorized personnel with access to confidential information to maintain their respective systems in accordance with industry security standards, as well as reasonable and appropriate practices, procedures, and systems, and continuing on, right?
Yes, that's what I read.
In this paragraph, what refers to industry security standards, would that refer to security standards used in the electric utility industry?
Yes.
So this provision essentially requires signatories to have utility level security controls in place, right?
I don't know what the term utility level security controls would mean. Security controls are, the frameworks used for them are, aside from regulatory requirements, are kind of standard across industries.
Okay. So, and this NDA provision requires signatories to verify and require that any authorized personnel with whom they share data must have these security controls in place, right?
Correct.
Okay, so looking at the data specifically here, this would likely prevent an aggregator from sharing this information with customers, right?
If they did not have the controls in place, yes.
Right, and as we discussed, or I don't think we actually discussed this, do you think a regular customer of the company has utility level security controls in place?
I do. I don't know that I could answer that. Some would, some wouldn't.
Okay. Can you explain the specific security risk of an aggregator sharing HCA data specific to individual customers with that customer? So sharing someone's own data with them?
Well, as I understand the data, and I'm fully admitting I have many skills, but I'm not an electrical engineer. As I understood the data, I don't know that it went down to the individual. I assume you're talking like an individual customer. If I understand your question correctly, and I'm honest, I'm not sure that I do, if I'm being honest.
All right, can you explain the security risk of an aggregator sharing information about availability at to connect generation or load at a specific customer's location with that customer?
We're talking the HCA data here, to be clear. Yeah. Can I articulate the risk? I think it's kind of laid out here is that if we believe this information is sensitive, and we do, and we require that information to be protected, and it's given to a customer that does not have those protections, then we don't know what is going to be done with that data and who is going to use that data and where that data will go. So yes, I believe there is a high risk of that data getting into somebody's hands that we would not want. If that answers your question. If not, I'm happy to articulate further.
I think we can leave that there, Mr. Marion. Thank you. Sorry, just reviewing my notes. I don't want to be duplicative of anything Mr. Schlesinger asked you.
No worries at all.
All right. Thank you very much, Mr. Marion. I believe those are all my questions for you.
Thank you. Have a good day.
Thank you, Mr. Chacon. Ms. Chacons, Tesla, 25 minutes.
Tesla will waive cross of Mr. Marion. Thank you.
UCA, 20 minutes.
Good morning. Sorry, it took me a minute to get my image to come up. Good morning, Mr. Marion. My name is Tom Dixon, and I am an attorney in the Attorney General's office, and I represent the Utility Consumer Advocate. It's nice to meet you.
Nice to meet you.
And also welcome to the world of utility regulation that you've apparently been involved in for 13 months.
I appreciate it. This was not one of the responsibilities I knew about when I applied, but here we are.
I want to talk about your rebuttal testimony, which is hearing exhibit 130, and would ask that that be pulled up, and particularly page 24. And you might look at lines 3 through 8.
Okay, I've read it.
All right, thank you. And this is what I'm going to be focusing on in our cross-examination. I don't believe you really raised any other specific issues with UCA. If we could just scroll down to footnote 23. This is the document you are referencing, which is Mr. Villarreal's answer testimony here in exhibit 601, and particularly page 27. Am I correct?
Yes, you're correct.
I hate to switch back and forth, but could we go to hearing exhibit 601 and page 27? And is there a possibility we could expand that and enlarge this? Mr. Marion, you had concerns with this particular image on Mr. Villarreal's, in Mr. Villarreal's testimony. Am I correct?
Yeah, I believe that the comment was on the prior document you showed, yes.
I'm sorry?
I believe the comments to that, yes, is the short answer. I believe it was what was worded in the last document.
And rather than go back to your testimony, I'm going to just read what you stated in the next sentence. And referring to this map, you said, but the map posted by PEPCO has significantly less detail and information than what was provided in Mr. Villarreal's testimony. Is that correct?
Yes, that's correct.
Again, I need to go back to his testimony now, again, here in exhibit 130, and we want to go to page 24, and particularly footnote 24. Just so it's clear, footnote 24 is what you cited in that sentence I just read. Am I correct?
You are correct.
Right. Now, do you happen to have with you Mr. Villarreal's testimony in front of you?
I do not.
Okay. Let's turn to footnote 24, and I would ask that we click on that particular footnote to see what comes up. Now, this is what you cited to as being an example of PEPCO having significantly less detail and information than what Mr. Villarreal provided in his testimony on page 27. Am I correct?
Yes.
Okay. if we could go to, there's a box on the right. If we could go to the second entry, just click on that. Are you familiar with what this legend is about, just generally?
Generally, yes.
All right. And then if we could go to the search entry one click above and type in, and by the way, Mr. Villarreal was referring to the U.S. Capitol area, Supreme Court area, et cetera, in his testimony. Am I correct?
I believe so, yes.
All right. So let's put in U.S. Capitol grounds, Washington, D.C., and click on that. Is that what you were referring to in the footnote, this document?
This webpage here, is this what I was referring to?
Yes.
Yes, it's just linked to it, so
All
yes.
right. Your Honor, I have had marked for identification here in Exhibit 610 because I've been advised that we cannot capture this document through the footnote, but that I needed to provide a separate document that would match this. So I would like to pull up here in Exhibit 610 that's in the UCA box.
Any objections, Mr. Simpson?
Is Exhibit 610 a screenshot of what we just saw?
Mr. Dixon?
I'm sorry, I didn't hear that. I apologize. Say again.
Is Exhibit 610 a screenshot of what we just saw?
That's the intent, and it was taken only 2 days ago in preparation for the case. But, and it's, as you can see, depending on how you expand or connect it, it does contain the area that was contained in Mr. Villarreal's testimony on page 27.
Oh, okay. That's no objections. I just,
Yeah, the only
sure I'm
purpose
following.
Yeah, the only purpose for this, I was requested to have some sort of exhibit because we couldn't capture what was on the in the footnote in the way we were going. Now, with that,
Hold on. So admitted.
Thank you, Your Honor. Mr. Marion, can you advise me how Mr. Villarreal's screenshot on page 27 of his answer testimony, hearing 0601, differs from what's contained in hearing exhibit 610, which is essentially a screenshot of what's in that, what you cited in your footnote? Were there any differences or inconsistencies?
One moment, I apologize, but I'm looking both at Mr. Villarreal's map and remembering the map we just saw. And I would note that this is at a much larger scale than the other map that Mr. Dixon was showing us, and that the map that Mr. Villarreal has on page 27 of his testimony.
Okay. And
so
sorry, Mr. Simster. Yeah, we can, as you'll note, there's a code down there to shrink it. I simply want to focus on the area that was in Mr. Villarreal's testimony, and if you want me to shrink it down to where it's closer to that, that's just fine. I'm only looking for a comparison of the data on Mr. Villarreal's map compared to the data on this map that matches that geographic area. And I'm asking, what are the differences between those two maps?
What are the differences between, I would have to have both maps side by side to see what the differences are.
And because we're doing this remotely, I don't believe we can get the two up.
Then I don't know that I could answer your question thoroughly.
If you were given time to subsequently look at the map that was in Mr. Villarreal and compare it to this exhibit 610, could you do that later then?
Yeah, that seems like a reasonable thing I could do.
Okay. Now, you did contend that, just so it's clear, that the map that Mr. Villarreal included was inaccurate and likely out of date, correct?
I did say that, yes.
And you also stated it had significantly less detail and information than what was provided in his testimony. Am I correct?
You are correct.
Right. Well, Your Honor, what I would recommend, again, if we were in person, this would be easy to do, is that Mr. Marion be given an opportunity to compare hearing exhibit 610 and the relevant portion of it that relates to Mr. Villarreal's map on page 27. And then perhaps he will be able to answer my questions and we'll be comfortable with his answers. Because this is all I have for this witness.
All right, so I guess what we'll do is we'll go to commissioner questions, see where we end up, and then come back maybe after lunch with UCA. Does that work, Mr. Simpson?
That works. Thank you.
Ms. Stanfield?
I wasn't sure if you had skipped over our cross intentionally waiting for timing reasons, but we also have reserved 90 minutes with Mr. Marion.
I missed that.
I was thinking you were rejiggering to take a break or something. Sorry.
That gives me far too much credit. All right, let's take this down. Mr. Dixon will continue with this after lunch. Ms. Stanfield, would you like to jump in here?
Thank you, Your Honor.
I can. I will say that I would benefit from 10 minutes to clean up what isn't already been covered, but I'm happy to dive in. It's up to you. Just for efficiency, I don't want to go over things that haven't been or that have already been, but I can do that on the fly as well. It's up to you.
Commissioner Gilman, did you have questions for Mr. Marion?
I do not, but we're finishing early, so if we want an early lunch to work all this out, that also works for me.
Commissioner Plant?
I do not have any questions for the witness.
Let me see if I can ask you a couple questions, Mr. Marion, and see if there's a path forward that may address this. And well, actually, let's break for lunch. Let's come back at 12:30, and we'll sort this out again. I have an idea to maybe bridge the gap, but let me talk to council. So let's come back. Let's take an early lunch break and come back at 12:30.
Your Honor, I will send hearing exhibit 610 to all parties during the break.
Thanks.
Thank you.
Bye.
Mr. Dixon, just to let you know, you're still on camera and unmuted.
Thank you. Yes, I'm just about to get off, but thank you very much.
All right. I guess, Mr. Dixon, my proposal would be to keep going with IREC and then let you finish up. Well, where are you at? You want to finish up with your questioning and then go to IREC? Where are we at?
I'm perfectly happy to finish up. I think I can finish this up in a few minutes. Again, if Mr. Marion's had sufficient time to review the documents and can respond to the questions, I'll have one or two. Or on the other hand, I can wait for IRAC. I realize I got in out of turn.
No, that was my fault. Right. Why don't we finish up, Mr. Dixon, jump to IRAC, and then go to Commissioner questions. Go ahead, Mr. Dixon.
All right. Good afternoon, Mr. Marion. Have you had an opportunity to review the documents that we discussed this morning?
I have indeed.
And I'm going to see if I can just cut to the chase. Would you agree with me that the map and the data that's contained on page 27 of Mr. Villarreal's testimony is identical to the information contained on here in Exhibit 10 for that particular area that's identified in his testimony?
So if I could make sure counsel correct me on this, but I would agree with that statement. We went and looked at over the lunch break, and I believe what happened is we looked at, although the same area, we looked at a different map, subset of that data. So I think that's where the discrepancy came up. But I would agree those are the same maps.
Thank you. I have nothing further.
All right, IRAC, 90 minutes. I'm hoping we don't need 90 minutes, but
me too.
You're up.
Yeah, certainly. I will try to be efficient here. And thank you, Chairman, for getting the chance here. Good morning or good afternoon now, Mr. Marion. I'm Skye Stanfield. I don't think we've met before. I'm counsel for the Interstate Renewable Energy Council, or IREC, and I'm going to ask you some questions that relate to your testimony. First, can you confirm that you did not file direct testimony and only filed rebuttal in this case?
I can confirm that, yes.
And you haven't filed other testimony regarding these security issues in any other case, is what I gathered from your earlier discussion?
That's correct.
Okay. I understand from your testimony, and again, at any point, if you want us to bring it up, we'll do that, that you and the company agree that there are benefits to publishing hosting capacity information to better inform users where to locate new load and generation. Is that correct?
That is correct.
I also understand that it's your opinion that publishing any form of a load hosting capacity map poses unacceptable security risks despite the benefits that they might have. Is that correct?
No, I don't think that's, I'm okay if they're posted as long as it's done in a secure fashion.
Okay, so my understanding is that the company has, in your testimony as well as in the testimony of Ms. McDermott, decided not to publish the load hosting capacity and didn't provide any pathway to doing that besides for this proceeding. So are you changing that position or?
No, I apologize. I misunderstood the question. I think part of the issue here is I sometimes still mix up some acronyms and some terminology.
There are
no,
plenty,
yes.
for sure.
The maps. The maps I have serious concerns over.
Okay, so you are saying, just to restate my question so we can make sure we're clear, that it is your opinion that publishing any form of a load hosting capacity map poses unacceptable security risks, despite the benefits that it may have?
Yes, that would be my opinion.
Okay, I also understand that it's your opinion that publishing the unblurred generation hosting capacity map or the tabular load data, the generation data, without requiring an NDA would also pose unacceptable security risks despite their benefits. Is that correct?
Yes, that's correct.
Okay. In making, go ahead.
You said the unblurred, correct?
Yeah.
Okay, yes, that's correct.
And I will mix up the blurred and the unblurred sometimes too, so feel free to, to ask me to clarify if I mix it up. In making these determinations regarding what constitutes an acceptable security risk, do you agree that the Commission will need to balance the benefits that come from publishing the data with the risks sharing that data poses to the security of the grid?
As long as they have a thorough understanding of both sides of that argument, then yes.
And has the company had the opportunity to present thoroughly its argument?
Which argument would that be?
The argument you just referred to?
I don't believe so, no.
Is that why didn't the company have an opportunity to present its argument here?
There's probably a number of reasons. And again, some of this, I know this has been going on long, predating me to some degree. I think that would take a much more detailed discussion of the risks that are posed. I could be wrong here, and I don't mean to offend anybody, but I don't think that the Commission has a deep understanding of the security risk. And if I'm wrong on that, I'm happy to be corrected. And I would think that to make a thorough decision, you would want to understand in detail the risks as well as in detail the benefits to come to a conclusion.
Is there a reason why you didn't do that in your rebuttal testimony or file direct testimony to lay that out for the Commission here in this proceeding?
Yes, I think that there are numerous components, but some of these components would have to be shared in a very confidential means. I don't mean like, I should be more clear. Some of this information would need to be shared in a classified arena and would not be something we could share in public testimony. In addition, I think we're getting
interrupt to clarify one thing. So in this proceeding, the Commission filed an omnibus motion for extraordinary protection of the load hosting capacity map and required all parties that wanted to access that map to sign the highly confidential NDA that the Commission provides. Are you saying that that wouldn't be sufficient?
Absolutely. When I say classified, I'm not referring to the information. I'm talking about the risks in general.
Mm-hmm.
And when I use the term classified, I'm not talking about how we would classify data. I'm talking about how the U.S. government would have classified discussions, which I am not at liberty to share that in any means.
So are you basically saying that there's no way to share that with the Commission?
We could likely arrange in coordination with our government partners to get them a classified briefing, even though I don't think they have clearances right now, but we could arrange that. Not in this setting and not in written form, though.
And you didn't think to offer that to the Commission to assist them in evaluating the arguments in this case, despite the fact that the statute requires them to evaluate it in this case?
Before I could offer that, I'm bringing it now as a possibility. Before I could offer that, I would have to clear that with several other entities.
Okay, I'm going to move on. So let me go back to the question we started with here, which is, do you agree at least that in determining what constitutes an acceptable risk, that the Commission would need to balance the benefits that could come from publishing the data with the risk sharing? I believe you said yes, but you would need to understand what information they understand about the risks. Is that right?
No, you're close. I don't think I need to understand. I would want them to understand.
Right. Okay. Fair enough. But you are agreeing that the exercise requires some balancing of the benefits with the risks in order to make that decision.
That's fair. Yes, absolutely.
Okay. In evaluating whether publication of the HCA data poses an unacceptable level of risk and what security measures are appropriate, would you also agree that there are multiple factors that the Commission should consider, including, but not limited to, whether the data is already publicly available via other means, whether there are adequate grid security measures in place, and whether there are recommendations from widely respected security experts on how to handle the data?
There's a lot to take in there.
I can go one by one if that's helpful.
Yeah, because I think some of them I agreed with you, some I did not.
Okay, and I'm proposing this as again, including but not limited to list. The first is whether the data is already publicly available via other means.
No, I don't think that's. I disagree that the other people have posted that, so I don't know that that's a fair assessment.
So evaluating whether or not it is already publicly available, is that relevant, or you just disagree with whether it is publicly available?
I disagree that it should be weighed as part of the decision. I think it's certainly okay to go look at it, but I mean, I've got personal information on the internet that I don't want out there, and it doesn't mean I would continue putting more out there. It's just, I think they're mutually exclusive in that area, if that's making any sense. And I don't know that my words are making sense.
Yeah, I think you're making sense.
Okay.
Thank you for that explanation. And we'll get to that a little bit more. Whether the second one was whether the data is, or no, sorry, the second one is whether there are other adequate grid security measures in place.
As part of the evaluation, yes, I think that would be
Okay.
done.
And the last one is whether there are recommendations from widely respected security experts, such as the ones you've cited, on how to handle the data.
Absolutely. Yeah.
Okay. I'm going to shift to another related topic here.
Okay.
In your testimony, and this is pages 13 to 14, if you want to reference it, you rightly emphasize that protecting the distribution system is crucial because the vast majority of customers are served by it. And I want to say up front that IREC agrees that protecting the distribution system is crucial. Would you also agree that it's vital to protect the bulk power system, and that attacks on the bulk power system could cause an even greater disruption than those on the distribution system?
I don't disagree with that, but I don't know that I'm not quite as much of an expert on to that level of detail. So I don't like to give a clear answer. If I had to say in general, I honestly don't know. It would depend on, I imagine, on redundancies built in. So I don't know that I don't disagree with your question, but I don't know that I have enough information to fully answer it correctly.
Okay, so you are not sure whether it's important to protect the bulk system, or just whether or not the attacks may have greater impact.
It's certainly important to protect it. The question of will they have a greater impact is where I don't fully understand.
Okay, that's fine. And that, just to be clear, and I know you already talked about with my colleagues earlier, that you haven't worked in the utility industry for a long time, and maybe this is a good chance to say, are you focused on just distribution, or I think you're the chief security officer for the whole company, right?
Whole company.
So you would be interested in the security of the company's bulk system as well as the distribution system?
That's an accurate statement.
Yeah. Okay. So it's my understanding from your testimony and earlier work we've done in this space that there are not specific standards, rules, or regulations that govern the cyber or physical security requirements for the distribution system, but that there are for the bulk system. Is that right?
I believe that's a true statement, yes.
Mm-hmm. And this is why you pointed to resources such as the North American Electric Reliability Corporation Critical Infrastructure Protection Standards. And if that's not a mouthful, I don't know what it is.
Yeah, that'll do.
And that stands for NERC-CIP. So you pointed to the NERC-CIP standards that set forth requirements that are technically only directly applicable to the bulk system, but may still be insightful for the distribution system. Is that right?
It's a fair assessment, yes.
Okay. Can you please pull up hearing exhibit 806? This is the company's response to IREC's discovery request 5-1, and which I believe you sponsored. Does this look familiar? And you can scroll down so we can see it more.
In general, this looks familiar, yes.
Okay. In response to question 5-1D, and if you could go down to that, I think it's probably on the second page, the response. You pointed to a few different sections of the NERC-CIP that you think are analogous and would require protection of the data or authorization for personnel with access. Is that right?
Yes, that's I think a good summary.
Okay. To my knowledge, maps, detailed maps of the bulk transmission system are widely published, both by transmission owners as well as by federal agencies. Do the NERC SIP standards prohibit publication of the locations of substations, lines, etc. at the bulk level?
With the caveat that I am still learning a lot about NERC SIP, and I'm not an expert by any means, I do believe that is a true statement.
Okay. So understanding that you're not an expert in the NERC SIP, are you saying that utilities, including your company, who publish maps of the bulk system or loading information such as the distribution system factor, are violating the standards or not?
I don't, again, with the caveat that I'm not the expert, and at some point I will be. Do I think we're violating the standards? No, I don't think so, because I don't think they're applicable there, as far as I understand.
Okay, so you in your discovery request response here, you cited to those as analogous, but now you're saying they're not applicable to, publication of the locations of the lines.
So you could give me maybe 1 minute to just reread what I wrote there.
No problem.
Okay, please ask your question again.
So I'm trying to understand whether you're saying that the company or other companies who publish the locations of the bulk system lines and associated equipment are violating the SIP standards.
If they are,
yeah, go ahead.
If they are subject to SIP standards, and as I understand it, not all are.
Is your company subject to the SIP standards?
I don't mean the companies are not subject to the standards. Of course we are. I'm talking more about the specific pieces of infrastructure that are beholden to those standards.
Okay, it sounds like you're not quite sure with respect to the locations of the transmission lines, whether they would be subject to the NERC SIP standards.
Yeah, I'm not fully aware of that.
So when you say that they're in the text that you just reread, they're analogous. Tell me how they're analogous to publication of the distribution lines, for example.
I think the term analogous would apply here to saying that I believe the data is equally sensitive, right? I would want to deny my adversaries access to any detail of any form like that. So whether at the local distribution level or much higher up the stream, as a security professional, I would want to deny that. And I see those data as both equally sensitive, if I'm answering your question correctly.
Okay, but the NERC SIP standards don't actually require that. So that's your opinion, but it's not the opinion of NERC.
Yeah, I don't know. I don't think so.
Okay, I'm going to move on from that. Thanks for that. I assume that you're, well, maybe you're not. So I shouldn't assume. Are you aware that the Federal Energy Regulatory Commission, or FERC, in a recent order called Order 2023, ordered transmission owners, including your company, Xcel Energy, to publish interactive visual representations of available interconnection capacity for the transmission network, which they call a heat map instead of a hosting capacity map, as well as a table of relevant interconnection metrics?
I am not aware of that. I don't think it's not ringing a bell, no.
Okay. So if I can pull that order up, let's do that. So can you open hearing exhibit 805? Okay. I'm representing that this is a copy of FERC's Order 2023, which was issued on July 28th, 2023. And do you want to scroll through it? I would like to, why don't I go ahead and just admit this or move to admit this to the record now?
Any objections?
No objections.
So moved.
Okay, so if you can go to pages 117, I believe it is, depends on what page it is on the PDF, but yeah, so can you go down 2 more pages? This is Can you scroll down a little bit more? I may have written down the wrong page number here, sorry. Can we go to paragraph 116? There we go. Okay, so somehow I missed the page numbers, but so in this proceeding, the commission was, the Federal Energy Regulatory Commission, or FERC, was considering whether to publish a heat map as described for the bulk transmission system. And in that, and I'll just represent to you that the commission considered multiple security arguments that similar to the arguments that you've raised here, including whether there would be grid security concerns associated with publishing this map and data. And I believe also that Xcel Energy weighed in this proceeding. Do you have any reason to disagree with that or believe that's not the case?
I have no reason to disagree with that.
Okay. And then can you go to paragraph 144, please? And I believe it's page 129, but maybe I mixed it up. There we go. I'll give you a chance to read this paragraph. I'll probably have to scroll down.
Okay.
Can you scroll down a little bit more just so I can see the rest of it? Thank you.
Okay.
Okay, so having read this, and I understand you haven't had time to spend with this document and the broader decision, do you agree that FERC considered and rejected the grid security arguments that the transmission owners and operators made against publication of the maps?
Based on what I read here, I believe that is what they said.
Okay.
Or the
Yeah, I understand you haven't had much time to spend with it, but that's fair. And I will represent to you that they did. Indeed, I will represent to you that your company is now required, pursuant to this order, to publish a heat map, including detailed information about the bulk transmission system without requiring an NDA. Do you believe that complying with the FERC order, if my representation is correct, will require the company to violate the NERC-CIP standards you've referenced?
honestly, Ms. Stanfield, I'd have to look at both of those just to confirm. We would not knowingly violate any standard, but I would have to look at both of those and probably get some legal counsel as well to fully understand.
Yeah.
But I don't know if I could, with the information I have, I don't know that I could accurately answer your question.
Right. I'm a little surprised that you don't know about this requirement, to be honest, because it's coming soon. But I understand that you haven't had a chance to look at it, and we can move on from from this if that's the case. But let me just ask one more question. Do you think, I don't know how much you've interacted with FERC, maybe not at all, but do you think the Federal Energy Regulatory Commission would require the company to do something that would violate NERC SIP?
I mean, I wouldn't. Would it be like two government organizations to not communicate and do something odd like that? Possibly. Do I think they would knowingly do it? I would see no reason why they would knowingly do it. And I do believe if we came across that, then we would raise that up to get clarification.
And I'm going to attest to you in here that you did not, the company did not raise that when it commented in this proceeding, but you can go back and check that. So if you had raised, it had been raised, do you think FERC would have still asked you to violate the NERC SIP standards?
I could say in a general statement that I don't think FERC would ever ask me to violate any standard.
Right. Okay. Okay, you can take this down. Thank you for that, Mr. Marion. I want to go through a couple more things that you cited in your rebuttal testimony. We can pull these up. I have hearing exhibits for them. Just let me know what you feel comfortable with. So in that discovery request that we were looking at earlier, which you sponsored, you also referenced again, here's a mouthful, National Institutes of Standards and Technology, Cybersecurity Framework 2.0, which I believe is referred to as the NIST CSF. Does that sound right?
It sounds perfectly right.
Okay. And do I assume that you are familiar, or can you tell me if you are familiar with the NIST CSF?
I am indeed.
Okay. Can you confirm that the NIST CSF is a guidance document and is not setting forth any binding requirements that the company must follow?
That's a true statement.
You reference the CSF section 2.0, and which lays out core functions. And you pointed specifically to identifier PR.DS, which I believe stands for protect and then data security. Does that all sound familiar? Okay.
It does sound familiar. And
again, if we need to pull this up, let me know. My understanding from reviewing that is that function relates to protecting the confidentiality, integrity, and availability of data at rest, in use, and in transit, or in transit and in use. Does that sound correct?
You're generally correct there, yes.
Okay. Does the NIST CSF define or otherwise provide guidance on what data should be considered confidential or sensitive?
No, I just stated it's a framework.
Okay, so it is the section you reference, the PRDS core function, points to how to protect data at rest, in transit, and use, but doesn't designate what data should be treated as sensitive, right?
That's a fair statement, yes.
Okay. Does the NIST CSF specifically recommend or require the use of an NDA to protect data?
To my knowledge, no.
Okay. Another report that you have referenced that more directly relates to the distribution system is the NARUC Cybersecurity Baselines for Electric Distribution Systems and DER, which was published in February of 2024. And you cited that in your rebuttal testimony. Does that sound familiar?
That sounds familiar, yes.
Okay. I'm just going to call that the NARUC Baselines Report instead of the whole mouthful. We're all good at that. I'm good with that. And again, I can pull this up as a hearing exhibit if that's helpful. Actually, let's do that just to make sure everybody can see it. It's hearing exhibit 810. Can you go to page 8, please? So I represent to you that this is a copy of the NARUC Cybersecurity Baselines Report. Does this look familiar?
It does.
Okay. Mr. Chairman, may I move to admit hearing exhibit 810 into the record?
Any objections, Mr. Simpson?
No, Mr. Chair.
Okay.
So moved.
Thank you. You point to section 2L, which is showing here on the screen. Can you read that for us?
Establish and maintain a process to identify and securely store sensitive data using strong access control methods for authenticated and authorized users and system applications. Document and implement equally or more effective alternative methods or compensated controls where exceptions are necessary.
Okay. Thank you. That was an accurate reading, I think. Does this section or any other section in this report define what constitutes sensitive data?
I don't believe so, no.
Does this section or any other section of this report define the exact methods that must be used to store and control access to sensitive data?
Not specifically, no.
Does this section or any other section of this report require or even recommend the use of an NDA to protect data?
It does not use the term NDA. No, I think it just says alternative methods.
Okay. And this report itself is a set of recommendations. It's not a requirement or something that's binding on the company, right?
That is correct.
Okay. Okay, can you take this down and please pull up hearing exhibit 812? Okay, this is a document that I put together pulling the various security reports that you cited in your testimony. We don't have to rely on this. We can look through your testimony for the list of these, but I thought it would be easy for you to see them all together. Are you comfortable talking about this? And if you could scroll down a little bit so he could see the full list, that would be great. We might need to zoom out to do that. There you go.
That's right. Your question was, am I comfortable talking to this?
Yeah.
Yeah, yes, I am.
So having pulled these from your rebuttal testimony, I assume that you've read and are familiar with all of these resources.
To varying degrees, yes. I've read them all, but familiarity to varying degrees.
Okay. Would it be fair to say that the entities that have authored these reports are some of the most credible and important agencies and institutions when it comes to grid security in the United States?
No, with the word grid security, some of them, yes, some of them are more broad to just security in general, not specific to the grid.
Okay, that's fair. Do you think that the entities that publish these reports, the ones that you've cited and are relying on to support your rebuttal testimony, are likely aware about the publication of hosting capacity maps?
No.
Is that because the company hasn't made them aware?
No. No, some of these don't deal with grid specifically, so they wouldn't have an interest in hosting capacity maps specifically.
Mm-hmm. So for these entities that are specifically focused on the distribution system, which I actually think almost all of these are, but maybe one or two aren't, do you think they would be familiar with the fact that I think over 75 hosting capacity maps are published in the United States?
I would have no way to know that.
Okay. If these entities were aware of the publication of these maps, understanding that you're not sure if they are, and in light of their incredible prevalence now in the United States and the level of data that they share, which you're well aware of, don't you think at least some of them might have issued some specific guidance if they thought there were grid security concerns related to publication of hosting capacity maps?
No.
Why is that?
If I go a bit higher level and I'll come down here. If I think about the types of sensitive information that an adversary would use, and I'm talking specifically to the grid, there are many components that would be critical. And I think for any of these organizations to come out and have a position on every single one of those pieces of data would be very out of the ordinary, unless it was something that had been regulated, again, as HIPAA, personal data, those types of things. Usually give general guidance on how to protect sensitive information, and a lot of times lead the determination of what's sensitive to the company itself.
Okay. And would you agree that companies like yours and other electric utilities take different approaches with respect to what they consider sensitive data?
To varying degrees, yes.
Okay. You can take this down now. In your rebuttal testimony at pages 9 to 11, you discuss how the company manages access to the hosting capacity maps. And we're mostly going to be talking about the generation maps now, just to reaffirm that the load hosting capacity maps are not public or are not available at all, except for the purposes of this proceeding, correct?
Correct.
Okay. So in particular, you describe how the company grants access to the secure data portal, which contains access to the unblurred hosting capacity map, the load and generation tabular results, and the GNA results, correct?
Yes, I believe that's correct.
Okay. And my understanding is that there are essentially 3 layers of protection built into this process of accessing the data portal. The first is the application process, wherein the company determines whether the user has a plausible and legitimate need for access to the data. Does that sound right? Step 1?
Yes. Step 1, yes.
And then the second is the creation of a username and password required to log into the secure portal and access the map. Does that sound right?
That sounds right.
And the final piece is that the company requires each user to sign an NDA, which is the NDA drafted by the company. Is that correct?
That is correct.
Okay. I also understand that these components are part of the company's broader risk security program, which you describe as robust. Is that correct?
That is correct.
Okay. I want to ask a few questions about these 3 different layers that I referred to. For the initial screening process, my understanding is that the company has effectively used this process to fairly quickly screen out about 10% of the parties that applied to access the maps. Is that correct?
Yeah.
Assumes facts not in evidence?
It's in we can bring it up. Reference Exhibit 806, which I think we just admitted, discovery request 5.1.
Okay, that's fine.
Okay.
I'll take your word for it.
This is I'm getting this, just to be clear for everybody, I'm getting this from your response to the data request that you sponsored.
No problem.
I'm sorry.
Okay. Should I go back to the question?
Please, if
Yeah,
you could.
no problem. So my understanding is that the company has effectively used this screening process to fairly quickly screen out about 10% of the parties that applied for access. Is that correct?
That feels accurate based on my memory, yes.
Okay. And I understand from that recent data request, which again, we're happy to pull up, that you sponsored, that the applications that were rejected were mostly due to applicants seeking information that isn't provided on the map or trying to resolve other customer issues. Is that right?
As I understand it, yeah, that I'm going off memory here, but that sounds right.
Okay.
Can we refresh his recollection by chance?
Happy to. Would you like us to pull up the exhibit 806?
Please.
And this is the response to sub C.
Okay. That is, if that's the question, I believe that is in line with the way you stated that.
Okay. And I guess I'll just note that you didn't note here that there were any users seeking it that you considered to be nefarious, so to speak.
Correct.
Okay. Think you can take that down now. If your memory has been refreshed, I don't think I have more questions about it. For the login itself, do I understand that by only allowing users with a login to access the data portal, that the company is able to verify users and to track any inappropriate or nefarious conduct to a specific user?
I would partially agree with that. The last part, it can be a bit challenging. Yes, tracked. Yes, activity. To what degree we can. Yes, nefarious activity. I think within this context could be a bit subjective. So if they take a screenshot, for example, well, I know that. Is that nefarious? It's hard for me to say specifically. But generally, the first part I agree with.
Okay. The company also uses a secure encrypted platform for the maps, right?
Correct.
Okay. Can you confirm that the HCA maps themselves, and here I'm referring to all three of them, the load, blurred, and unblurred maps, are also what I think the term is air gapped, such that accessing the maps would not provide someone a way to access the utilities control system or other internal information via the map?
Yeah, sure. Hope not. Yeah, that's a true
I
statement.
hope not too. Okay. So is that a yes then, that you believe they are air gapped?
I know they're air gapped. Yes.
Yes. Okay, great. Would you say that the login, application screening, and the encrypted platform for the maps provide protection that exceeds that which is used by the majority of other utility hosting capacity maps in the United States?
I would have to kind of speculate because I haven't looked at all of them. Based on
Objection calls for speculation.
Okay. Let me just ask another question.
Oh, go ahead.
Go ahead. I don't need him to speculate. I want to understand why you haven't bothered to, in preparing for this proceeding, in submitting your rebuttal testimony, to actually investigate what other utilities are doing with respect to publishing their hosting capacity maps.
It's a fair question. I think it goes back to an answer I gave prior, which is there are thousands, literally thousands of types of sensitive information. And to your point earlier, companies look at them differently.
Mm-hmm.
We don't, as a practice among my peers, whether in the utility space or out of the utility space, discuss specific types of information, how we protect that. We will talk again about strategies, policies, adhering to regulatory standards and so forth, technology, but we don't get down into specific data. So when it came to the HCA data itself, whether tabular maps or whatever, based on my professional opinion, and again, it's based on almost 3 decades of dealing with sensitive information and dealing with nation state actors, I consider that information incredibly sensitive.
Okay. And I assume that other utilities in the United States, including those shown on the list that Mr. Schlesinger showed you, largest utilities such as Pacific Gas and Electric, Con Ed, et cetera, I assume they also have security experts who are evaluating whether the data is sensitive. Do you believe that would be the case?
Oh, yes, I believe that would be the case.
And you just believe you disagree with them?
Well, in the case of PG&E, as I recall, they had a similar discussion and were required by the Utility Commission to provide that data. So I don't know that their security experts came to the same conclusion.
Mm-hmm.
And I couldn't speculate on how or why they came to that conclusion. Was it different from mine? I don't know. They could have been overruled by business leadership, customer. It could have been a number of reasons, and I don't know why.
Okay, and just one last question on that same line. Like, I guess I always find it interesting that utilities don't talk to each other very much, and I understand that that's the case. But I feel like in this space where we're trying to grapple with, what is the right way to protect this information? And more corely, the right way to protect the grid, which we all agree is super important. I just wonder why there's not any shared learning about how one utility is protecting it over the other. And I'm curious if you have thought about talking to your other utilities about how they're managing these risks differently than the company is.
So the first part of your question is more of a statement, which is an inaccurate statement. We do talk on a regular basis. But to my point prior, there are thousands of types of sensitive information. If I asked my peers about how they protect each single one, that is all I would do. So again, we talk about how do you protect sensitive information in general. Back to your discussion, even NIST doesn't say, here's how you protect this or this. It says, here's how you protect sensitive information, and it leaves the determination to what sensitive is to the individual company.
Right. And different companies have different opinions on that.
They do, yes.
Okay, I'm going to move on from that. And thank you for your patience as we talk through those different resources. So you've had to talk about the NDA a fair bit. I'm going to try to be pretty efficient with these. I am going to have to ask you to repeat some of your positions just because I want to make sure I got them right.
Okay.
So in your rebuttal testimony at page 15, you state that in your experience, NDAs are commonly used as one tool among many to limit risks. And you reference that you commonly sign them yourself and have, interacted with them many times throughout your career, it sounds like. You also state that NDAs are particularly useful because they don't completely bar access. Instead, they allow for access. Does that sound familiar?
That does sound familiar, yes.
Okay. Do you concede that whether or not they allow for access may depend on whether the terms of the NDA are reasonable and achievable?
Okay, I'm sorry. Can you repeat that again, please?
Certainly. And I can go slower. I have a tendency to talk fast. I apologize. Do you concede that whether or not they, quote, allow for access may depend upon whether the terms of the NDA are reasonable and achievable?
So I think the word I'm stuck in is whether they allow access. I think they allow access whether or not they're achievable.
Wait, so explain that to me.
Well, I mean, if I decide, a company decides to sign an NDA, we've seen enough times where people sign NDAs and don't necessarily have the wherewithal to adhere to that NDA. I'm not saying that's the right path, the legally acceptable path, but that's the reality. So do they have the capability? I mean, I don't, the whether is the word I'm stuck on. I do think.
Go ahead. You finish. I don't want to interrupt you.
I do think that that would be an expectation, I think, but I don't know that that's reality, if that makes sense.
Yeah, I think maybe I'm referring to something different with the word achievable, actually.
Okay.
So I'll state it again just with refined. So you had said that NDAs are useful because they don't bar access, and instead they allow for access. So my question is whether the exact terms of the NDA and what it requires of the signatory matter when determining whether or not they allow for access. And I'll give a specific example. So if the NDA, and I'm not being totally hypothetical here because this is what the company's NDA does, requires a signatory to have a certain level of data security in place, for example. And that is something that the interested signatory doesn't have in place, then wouldn't it actually bar access?
Well, they would be, wouldn't it bar access? Yeah, for any reason, if they don't sign the NDA, it would bar access, yes.
Right. And so whether the terms are reasonable and achievable, meaning whether they're terms that people can reasonably agree to and sign, alters whether or not they allow for access.
Yes, that's a fair statement.
Okay. And I think you just said this a second ago, but I just want to highlight it again to make sure I heard you correctly. Would you also agree that whether or not an NDA is actually effective from a security standpoint also depends on the terms in the document?
In practicality, no. From a legal perspective, I understand what you're saying, and I think that's fair. I think in practical use, me not being an attorney, when I sign an NDA, I try to, as best it here, but I think let me take that back. I think that's a fair statement.
Okay. I think you're getting to what I was going to ask a little later too, which is, do we agree that not all people that sign NDAs are actually complying with them?
I have no way to confirm that. I would say that is a very logical assumption.
Okay. And when that happens, the NDA is not really providing a lot of protection because it's not really stopping people from sharing the data, right? Or doing whatever it is that the NDA is designed to prevent.
I see an NDA as a deterrent, but at the end of the day, the user's going to do what the user's going to do.
Mm-hmm. Okay. When an applicant signs your NDA, the company's NDA, does the company verify whether they have the required data security in place?
It's a nuanced answer. No, but we are trying to start to do that.
How are you going to do that?
So, well, if you go back to the NIST framework we talked about, there's a section there tied specifically to third-party supply chain security, things like that. Mm-hmm. And what it talks about is, among other things, is when you have an agreement with a third party, whether an NDA or some other contract, you have a mechanism to go confirm that they're adhering to the security controls that are built into that. This is not something I think that most companies have been very good at, but we're all trying to get better at now and going back and executing those rights that we have to confirm that they are meeting the standards set forth in the agreement.
Okay, so you're basically just going to ask them to confirm.
We typically ask them to confirm with proof. And that proof could be through a third-party audit. It could be through, so with NIST, if they've had a NIST assessment that they can give me that's been validated by a third party, that would be acceptable too. And what we would do is we wouldn't go to every single party. We go to where we think parties hold the most sensitive information so we can focus our efforts appropriately.
So for the NDA that's required for the web portal, are you suggesting that you're going to do that for this?
No, I'm not suggesting that. I don't know that we have not specifically discussed that yet.
Okay.
With tied to the portal.
Would you agree that shielding data that developers very much need to do their business competitively behind an NDA might incentivize them to sign an NDA even if they don't have the proper security measures in place?
Incentive, I would hope they wouldn't. But I'd have to speculate there. I don't know.
You don't need to speculate. That's fine. Give me a moment to make sure I'm not asking repetitive questions here again. So I understand from you, correct me if I'm understanding this correctly, from your discussion with Ms. Judkins, that you have not reviewed the commission's NDAs and compared them with the web portal NDA. Is that correct?
I have read it. I have not compared it though to the web portal NDA.
Okay. Were you involved in the decision the company made not to publish the load hosting capacity map publicly?
No.
Okay. Were you involved in the decision to allow parties in this proceeding to access the load hosting capacity map if they signed the highly confidential NDA?
That precedes me as I understand it.
Okay. So do you know what that NDA requires? Maybe you don't if you weren't involved.
I have read the NDA a couple of times. Do I know what's in off the top of my head? No. Am I familiar with it? Yes.
Okay. Should we pull that up, or do you want me to pull it up if I want to ask more questions about it?
Probably depends on the
Senior
question.
counsel wants me to do that, so I'll do that. I believe it's Exhibit 809. And what we included here was the ones that we signed, just as an example. Can you maybe just scroll through these so he and everybody else can read these? Might need to give him a second more to
Yeah.
read.
Oh, am I supposed to read here? Yeah, I don't read that
Well,
fast.
I'll ask you questions and we can go back. Maybe that's the way to do it.
Okay.
So my first question here is, I'm just going to confirm that these terms are different than the terms in the web portal NDA.
Yes.
Okay. Does this NDA here require parties to have specific data security measures in place?
This is this is not the web portal NDA, correct?
No, this
I don't
is the
believe
highly
this.
confidential NDA.
I don't believe so. It does no.
Okay, so why did the company decide to allow parties to access the load hosting capacity map, signing this NDA, if they don't have any, it doesn't require any data security measures in place?
If I'm following the two different NDAs correctly, I believe the decision to do that was made prior to my tenure here. I believe.
Okay. Again, give me a moment. Okay. You can take this down now. I'm going to confirm my understanding of a couple of things you discussed with Ms. Judkins, and then I promise, Chair, that I am almost done here. You discussed paragraph 10 of the company's web portal NDA, and we can bring that up again if you'd like. And I believe that's the section that she walked through with you that indicated that the signatories have to have industry security standards. Do you recall that?
I do recall that with the discussion, yes.
And did I hear you correctly to say that you believe those are utility industry security standards? Like the industry referred to is the utility?
No, quite the opposite.
Okay, explain.
Aside from, regulatory requirements, NERC, things like that, I'm unaware of any specific utility security standards. They're baselines, they're guidelines, or things like that. But a hard, fast standard, I'm not aware of any, again, outside of the context I gave.
Okay, again, so in the NDA, when it says industry security standards, what are those standards?
It's a fair question. Typically, when we use the term industry, we're talking about business. So how I would interpret that, and I understand that maybe others would come to a different interpretation, would be aligning to NIST CSF, as you mentioned earlier. There's ISO, there's a couple other 3 to 4 broad standards that industry, being companies, whether utility or Tesla, would generally adhere to as best practices.
Okay. The term industry security standards isn't defined in the web portal NDA, is it?
To my knowledge, no.
How would a party who signed that NDA, and I understand some number have, know whether they have, quote, industry security standards in place?
I would hope they would confer with their internal teams. Again, I'd have to speculate. I don't know how they would reach that conclusion.
But it's not, yeah, because it's not defined, right?
No, not in the NDA.
And again, I think you covered this with Ms. Judkins, so I just need to confirm. Is your belief that most parties that would want to access the hosting capacity maps, both load and generation, for the purposes of this discussion, have this undefined level of data security in place?
Well, I would hope that if they signed the NDA, they did, but I don't have any way to confirm that.
Do you think most companies who would want to access the hosting capacity maps do have this level of undefined industry security standards in place?
I guess where I'm struggling here is just in the definition, because, and I get it. I fully understand what that sentence means, and I know what I would do about that, but I also understand this is what I do for a living. What I hope, I don't know all the customers that have requested access off the top of my head. I would hope they had reasonable levels of security in place to protect that data. But again, I have no way to confirm that.
Okay. In your rebuttal testimony, you expressed some concerns about the legitimacy of developers or other entities who contend they're unable to execute an NDA. That's on page 17. Does that sound familiar to you?
It does sound familiar.
Okay. In light of the conversation we just had, well, actually, first, when you say you're concerned about them being unable to execute an NDA, are you referring to just NDAs broadly, or the company specific NDA, or the commission's NDA?
Broadly.
Broadly. Okay, so in light of the conversation we had about your specific NDA just a moment ago, do you agree that it's maybe not so unreasonable that parties would have a hard time signing that NDA, considering that it doesn't define what they actually need to do to comply with it?
The fact that the line of questioning all day today, I think would lead me to that conclusion.
Okay, thank you. Okay, I'm going to move off. There's a lot more in that NDA, but I appreciate that the commission and that you weren't involved in it, and I'll just move on from that at the moment. I have a couple more general questions about your position on NDAs, and then I'm done. In light of the conversation we just had, which is, that these NDAs are really different and that it's hard to know what you're doing when you're signing those NDAs, and that you haven't even considered whether when you made your recommendations, what the terms of those NDAs are. I'm wondering if you would be willing to concede that there may be other ways of reducing risks to an acceptable level besides using an NDA?
I don't know that I would agree with that, with the exception of the controls we've already put in place, the username and password, that kind of deal.
So you have all of those provisions in place. You have the ability to require an application where somebody has to specifically ask you for permission. You have the web portal or the login, and you have your general grid security provisions in place. But you think you're not willing to say that there might be some other measures that would protect without an NDA.
There might be, off the top of my head right now, I can't think of one, but I would concede there might be.
Okay. I will represent to you that I have looked at every hosting capacity map that has been published in the United States that is publicly available as listed on the DOE's Atlas of Hosting Capacity Maps. And I'm happy to pull that up if you'd like to see it. And my understanding is not a single one of those maps requires an NDA to be signed to see them. And I understand that you don't know that, and you're going to have to verify that. But if that was true, can you tell me that you think that all of those other utilities, some of which are doing this voluntarily with no commission order, are putting their systems at risk or do not have other measures to sufficiently protect their grids?
To your first question, I absolutely disagree with the approach they've taken. Emphatically disagree with posting that data publicly. To your second question, do they have additional controls? I could only speculate on that. I assume so, but I wouldn't know.
Okay. I have no further questions, Chairman, and thank you very much, Mr. Marion.
Nice to meet you.
Likewise.
Thank you, Ms. Stanfield. It sounds like Commissioner Gilman, you don't have any questions. Commissioner Plant? I guess I just have a couple. Mr. Marion, can we pull up hearing exhibit 801, attachment 5, section 6, and this is just the NDA that I think we saw before. And I guess I'd just start, in your experience, is it typical to have specific performance provisions in an NDA so explicitly stated? Yeah, if you can go to section 6.
Give me a moment to read it out. Okay, could you please ask your question again?
Yeah, in your experience, is it typical to have specific performance provisions in an NDA so explicitly stated?
In my experience. Honestly, Kevin, I don't typically get down into the details of every single NDA, and I honestly don't know. I guess is the best answer I could give you.
All right. And are you aware if the company has ever enforced one of these NDAs against any users of the web portal?
I am not aware either way.
Okay. And you're probably not going to have an answer to this question either, but I'm going to ask it anyway. Assume for purposes of this question that the NDA was modified to say something like Xcel Energy may seek any relief to which it may be entitled at law and or in equity, and then took out most of the rest. Do you have a view whether that might work for you?
I have to put that to my legal team. I don't know. If the question you're getting at is, are there opportunities to improve this? I would generally say probably. The specific verbiage, though, I would have to defer to my legal team.
I understand. If we can go down to 10 for a second. And do you see where it says maintain their respective systems in accordance with industry security standards? I think you talked about that with Ms. Stanfield extensively.
Yes, we did.
And any thoughts of it just changed to something like maintain their respective systems in accordance with standard business practice in Colorado to protect confidential data? Any thoughts on something like that?
It would be a similar answer, Chairman. In general, I think there are opportunities to improve here. Yes, the specific verbiage, again, I'd have to defer to the legal team.
All right. And last question, and I think you may have already answered it, but any thoughts about developing a revised NDA that really tries to address the concerns raised by the parties to this proceeding? I mean, it just seems like people sign NDAs all the time, but this one seems like it may be over the top. So thoughts about trying to negotiate something that's more in the middle ground?
I am generally supportive of that, yes.
That's all I got. Redirect Mr. Simpson.
Thank you, Mr. Chair. If we could bring that NDA back up, I think that we can go through a couple of questions, and that's hearing exhibit 801. If you could scroll to the top, paragraph 1, please. And just for the record, Mr. Marion, you are neither a lawyer nor an engineer, electrical or otherwise, correct?
I am not.
Okay, just making sure. Here, confidential information is identified as specific type of distribution grid data and information identified as being non-public by Public Service Company of Colorado. You see that?
I do see that, yes.
So does that mean all information being provided is confidential, or only that specifically identified by Public Service?
Can you repeat the question again to make sure I get my
Sure.
answer?
Does that mean all information being provided in whatever interaction is occurring is confidential, or only that specifically identified as confidential?
And we would provide other information.
Yeah, okay. If we can scroll down to paragraph 6, please. No, sorry, paragraph 10. And In preparation for this hearing, did you go through the secure portal? Are you familiar with the secure portal?
I did, and I am.
Can you download any of the secure information from the secure portal?
Yes, you can.
Which information can you download?
Pretty much anything. I mean, through other means, screenshots, copy paste, those kind of deal.
Okay, but you can't actually direct download let's say the HCA map itself and have it operating on your computer.
No, you cannot.
Okay. And in the aspect of the current portal, that's really the information that's being sought to be protected, correct?
That's correct, yes.
And so the reality is using the secure portal moots this paragraph 10, or said differently, other entities don't actually have the ability to store the confidential data because it's all locked up in the secure portal.
Yeah, I believe that's a fair way to put that.
Okay, if we can roll up to paragraph 6, please. There's been a lot of discussion today about the Commission's NDA and Xcel Energy's NDA. You've been asked many questions about that, correct?
I have indeed.
And would it surprise you to learn that if there's a breach of the Commission's NDA, that the Commission can go enforce that?
It would not surprise me, no.
And if there's a breach of your NDA, is it the Commission's role to enforce your NDA?
I would not think so, no.
No, so Xcel Energy needs an opportunity to go ahead and be able to enforce its own NDAs if there are issues.
That's correct.
And paragraph 6 is intended to ensure that Xcel Energy can enforce its own NDAs.
Yes.
And if highly confidential information was released out into the public, you know, is there any kind of monetary compensation that would make up for that happening, in your opinion?
No.
Would Xcel Energy want to mitigate the leakage of that information as quickly and immediately as possible?
Absolutely.
Okay, thank you. All right, we can take this down. We just went over the fact that you're neither a lawyer nor an engineer. So how do you educate yourself about the kind of material and make an assessment that it's sensitive?
I talk to lawyers and engineers.
And did you talk to lawyers and engineers with respect to the load HCA map?
Extensively.
And did that include any of the witnesses in this proceeding?
It did.
Okay. And in those discussions, did they demonstrate to you why that information is highly sensitive?
To a degree, yeah. They demonstrated to me what the data was, how they used it. I then could determine through discussion with them how an adversary would use that information. This is how I came to the determination with their input that that is highly sensitive information.
And with respect to that highly sensitive information, from your perspective, the load HCA map meets that definition.
Absolutely.
And you're the Chief Security Officer of Xcel Energy.
I am.
Okay. So you were asked the question, didn't you provide enough evidence in this proceeding to make your case? Do you think your testimony provides a reasonable assessment with respect to what you can provide publicly with respect to your nature and concerns of bad actions?
There's probably more I could provide, but I think some of that might be redundant. So that's probably a fair assessment.
And would it be fair to say that some of the SMEs that testified in this proceeding have at least provided for the record their concerns about the sensitivity of the load HCA map?
Yes.
And if, as you noted, the company's position is if the commission wants to make this information available, they should do it in a separate proceeding so they can be fully briefed on all the pros and cons. Is that correct?
That is correct. Would you say that it is that
the company's balance of security of this information and reasonable access to it for developers and to further their economic interest is an important part of trying to measure what to do with this.
What to do with this, as in to releasing the data?
Correct.
Yes.
If the commission were to order the company to release the data, would the company comply?
Absolutely.
Would the company comply even over its demonstrated security concerns?
We would comply with the commission.
Okay. You had a discussion with Mr. Schlesinger. I believe that was hearing exhibit 969. Let's pull up 915. Can we pull up a hearing exhibit 915, please?
Sorry, just taking a second.
Nope, no worries. And can you scroll, I think it was page 27, if I recall correctly. Mr. Schlesinger might be able to help me. Can you keep on going down? Some more, keep on going, keep on going. Scroll up, then maybe it was 25. My apologies. There it is. All right. This was the last available information in the record with respect to public availability of HCA data, correct?
Correct.
And this, if I'm looking at in the definition section, do you see that? That
I
is,
do, yes.
Yes. All of them say hosting capacity. Is that correct?
That's correct.
Okay. And if I'm looking now, Ms. Stanfield and Mr. Schlesinger both represented to you, subject to check, that those who allowed detailed public information or high-level public information, none of them provided an NDA. Is that correct?
That's how it was explained to me, yes.
And the same with restricted. Is that correct?
Yes.
If I'm looking at this, that still means 56% of all polled utilities do not release this data, correct?
Correct.
That's more than a majority.
That is correct.
And at least one, PG&E, has released this data because they were ordered to, not necessarily because they thought that was in the best security interest of the utility.
That is correct.
Okay. And so there's not much we can really learn if we're talking about 7 and 9 utilities and how they handle it, given that's, you know, less than 30%, less than a third of the sample size here, correct?
Correct.
Okay. We can take this down. You had a discussion with Ms. Judkins regarding, are you aware if HCA data has ever been used in a coordinated attack? Is that, you remember that?
I do remember that, yes.
And it feels to me like if you had listened to her questioning of Ms. McDermott and Mr. Mino, that there appears to be some kind of interest in saying, if this has happened before, then we should protect it. Do you think that's a fair characterization of the tenor of those questions?
Yes, I do.
And do you believe that if there's a reasonable threat and reasonable concern about something, even though there hasn't been a past attack, using that specific information, that should make it that the information should be publicly available?
Oh, no. If I could clarify one point there is that, again, I've been doing this for a bit, and I mean, to be specific, 27 years. I don't, my role and my responsibilities do not tell me that I must build strategies to respond to things that have happened. I have to anticipate what is going to happen based on the information that I have. And we say constantly that our attackers have to be right once, and I have to be right all the time. And there's a lot of truth to that. So I need to go out and assess risk as best as I can, given the information I have. Yes, we do take prior events into account. We take peer information where we can into account, all those types of things. But ultimately, the decisions that I recommend and make are based on all types of data, including things that we think are likely to happen or possible to happen, but have not happened yet.
Okay. Two more questions. You had quite a long discussion with Ms. Stanfield. One of the things she raised was the reality that there are maps and locational information of the bulk electric system. You remember that?
I do.
Is the company, with respect to the HCA load map, is the company concerned about the location information, or are they actually concerned about the system performance and loading information in map form? What's the main concern?
Oh, it's absolutely the latter. You know, I think as I read through testimony, a lot of people rightfully pointed out this date. A lot of these things can be found on Google Maps. To your prior question, that would go into my decision factor. If I can't stop it, I can't. But when it comes down to what is really of concern, it's not the location. Sometimes maybe it's what's feeding through those and how, what capacity they're at.
I got you. And so notwithstanding that, Ms. Stanfield also talked about the fact that FERC has ordered essentially heat maps for the bulk electric system. You remember that conversation?
I do indeed.
Have you reviewed any of those heat maps or any of the information that Order 2023 cited?
I've seen the heat maps, reviewed the order, not in detail, no.
Would you be surprised if I were to represent to you that the level of granularity of those heat maps does not reach the down to the premise level that is contained in the HCA load maps?
Would I be surprised? No, I would hope that they weren't.
Okay. I have nothing further.
Thank you, Mr. Marion. Welcome to this process.
Thank you, Chad.
And you can be excused. Thank you, sir.
Thank you. You have a wonderful day.
You too. Mr. Pascucci, can you hold up your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth? Oh, you're muted somehow.
Apologies for that. I said I do. Hopefully you can hear me.
That works. You put your hand down. Is anybody with you or communicating with you in any way?
No.
If that changes, will you let us know?
Yes, I will.
Let's see. Mr. Dunbar, I got 2 hours. We got an hour and 15, 20 minutes till we break. Let's see if we can, how far we can get.
Thank you, Mr. Chair. I'm happy to go. I don't know if it makes more sense to defer Mr. Pascucci to Tuesday to not interrupt the flow, or I'm happy to go now. It's up to you.
I'd strongly prefer that you go now and get as far as you can. So it's a little before 2 and you got 2 hours.
Sounds good. Thank you. Good afternoon, Mr. Pascucci.
Good afternoon, Mr. Dunbar.
I believe we've met before, but it's good to see you. It's a pleasure to be in the enviable position with you of standing between everyone's Labor Day weekend. I'll try to keep this as interesting as possible. So let's dive right in. I'd like to start with your rebuttal testimony, please. And I'm not sure who's driving today, but if we could pull up hearing exhibit 129, please. Thank you. Page 19, line 10. So the question here asks you about customer interest in Green Button Connect and related services. And at line 12, you state, Overall, the company's understanding is interest in the Xcel Energy GBC platform, GBC stands for Green Button Connect, specifically is about average for other utilities. The company's implementer provides similar services for other utilities and has not found a material disparity between participation in the Xcel Energy platform implementation and other utility implementations. You see that?
I do.
And the next sentence notes that a grand total of 65 customers in Colorado use the company's Green Button Connect system. The company's Green Button Connect implementer is Franklin Energy, correct?
That's correct.
Do you know what the length of the contract is with Franklin Energy?
I do not.
So you don't know when that contract is up for renewal?
I do not know.
Did Franklin Energy provide the company with a list of these other utilities and their Green Button Connect participation numbers?
No.
Other than Franklin Energy, did you conduct any surveys or consult any other resources to support your conclusion that customer interest is about average? Customer interest in Green Button Connect is about average?
No.
So really the only information we have is that customer uptake is about, the company's customer uptake is about average among those utilities for which Franklin Energy is the implementer, right?
Yes, that's correct.
And so in that case, it's entirely reasonable to conclude that when Franklin Energy is the implementer, customer uptake of Green Button Connect tends to be low, but uptake tends to be higher for other Green Button Connect implementers, right?
I don't know that I would agree with the conclusion you drew there, no.
Why not?
Well, my understanding is Franklin operates in several different states for several different utilities. They indicated some states they see, as we said, we are about average. So some states are seeing higher, some states are seeing lower. I don't think it would be an accurate conclusion I don't think it would be accurate to come to the conclusion that Franklin Energy is the cause for Colorado's level of interest.
But based on the data we have, we can't rule that out, that Franklin Energy is the reason for the company's low uptake, correct?
We can rule that out, just as we can't rule out any other reason.
Okay. Would you agree that generally speaking, customer uptake of Green Button Connect is likely to be higher when the software is easy to use and likely to be lower when it's difficult to use or has lots of bugs?
I think that's reasonable, yes.
And do you recall that Mission Data's first recommendation in this proceeding is that the commission order public service to fix Green Button Connect, and if the fixes are not completed within 6 months, to order public service to procure a new Green Button Connect platform through an RFP process?
Could you reference me to where in, I believe it's Mr. Murray's testimony you're talking about? Can we bring that up?
Certainly. It's hearing exhibit 1500. And let me find you a page number. That recommendation appears on page 8. Starting at line 5, and the RFP process is referenced on line 12. And please let me know when you've refreshed your memory on that.
Yes, I have. Thank you, Mr. Dunbar.
Yeah, thank you. Your testimony does not respond to that recommendation of Mr. Murray's, correct?
I don't think I respond directly to the statement that we should be required to do an RFP in there. I do respond to the general conclusion that is drawn here in I'll say recommendation number 1 beginning on line 5.
Okay. And well, that's okay. Let's turn back to your rebuttal testimony, please. And that was 129. If we could look at page 18, please. Thank you. Line 11, you say, it appears to me that mission data engaged with the software with the objective of discovering problems and was determined to find them. And you're talking about Green Button Connect when you say the software there, correct?
Yes, that's correct.
Have you or someone on your team or maybe a consultant ever engaged with the company's Green Button Connect software with the objective of discovering problems?
We have a program management team as well as the Franklin team that supports it that, yes, I believe engage with the software to understand the user functionality and the functionality of the software.
Do they engage with the software with the objective of trying to find problems?
I don't know if they engage with the objective of trying to find problems. My understanding would be they engage with the intent of ensuring that the software is working correctly, that the functionality is there, and seeking to improve the user experience based on the feedback that we receive from customers.
Okay, so you would agree that before offering software tools to customers, it's important to test them out to try to minimize the number of problems that customers might encounter in the real world, right?
Yes.
Would you agree that customers are likely to have a wide variety of tech savviness?
Yes.
So there's likely to be some customers who are pretty comfortable using complicated software and some customers who, at the other end of the spectrum, who just won't use the software if it's too complicated, right?
I think that's probably a reasonable conclusion.
Has the company ever tested its Green Button Connect platform by working with a random sampling of real customers to see how many of them can successfully share their data with an authorized third party?
I don't know if the company's ever done that.
Okay. Do you recall that Mission Data recommended that the commission direct public service to hire an independent consultant to report on the experiences of a random sample of customers who tried to share their data through Green Button Connect?
Yes, I do.
And you didn't provide a response to that specific recommendation in your testimony, correct?
I don't think I specifically responded to that, but I think I, again, have generally responded to Mission Data's concerns regarding the user experience that Mr. Murray had that informed his testimony.
Okay. Mr. Pascucci, are you a public service customer yourself?
Yes, I am.
Have you ever tried to share your own electric usage data with a third party through Green Button Connect?
No, I have not.
So you have no reason to question Mr. Murray's finding that for a customer to share their data through the company's Green Button Connect system, it requires 9 separate steps.
I don't have a personal experience that would differ with Mr. Murray, and
Okay. If we could look at page 16 of your rebuttal testimony, please. Thank you. Starting at line 4, you disagree with Mission Data's recommendation that there should not be a default 2-year limit on data sharing, after which a customer has to reauthorize the third-party access. And let me state that maybe I had some double negatives in there. The company's proposal is that customers can only authorize data sharing through Green Button Connect for 2 years, after which they must reauthorize data sharing, correct?
Yes, that's correct.
And Mission Data opposes that recommendation, and here you respond to us. If we could, I'd like to introduce what's been marked as hearing exhibit 1506 in Mission Data's box, please. Thank you. Mr. Pascucci, are you familiar with this form?
Yes, generally.
So you'd agree that this is the consent form that appears on the Commission's website that customers can use to authorize their utility to share their data with a third party, correct?
Yes, I believe so.
And in the upper right, you see the label that we've put on here to mark it for this proceeding. Do you see in the upper left, it shows that this document originated as attachment E to decision number R150406 in proceeding number 14R0394EG. Do you see that?
Yes, I do.
Okay. So is it your understanding that this commission-approved customer consent form does not specify a 2-year limit on customer data sharing?
Could I ask if it's Ms. Federico, or whoever, could we scroll down just a little bit? Just to be able to see the whole page? As I understand the section there, data collection period, it does not set a date at which it's going to be terminated, but it does allow the customer to set a date or otherwise note when it will end.
Okay, but thank you for that distinction. So if a customer fills this out and checks the box that says be effective until terminated by you, is the company going to stop sharing that customer's data after 2 years?
No, I don't think we would.
Okay. And public service doesn't have an automated process in place to notify customers that their 2 years is almost up and they need to reauthorize data sharing if they want to keep sharing, right?
That's correct, yes.
Okay, thank you. If we could please turn back to your rebuttal testimony. Is it Ms. Federico with us today?
This is April, Ms. Crane.
Ms. Crane, hello, thank you. I'd like to
admit hearing 1506?
I'm sorry.
Do you want to admit into the record hearing exhibit 1506?
Thank you, Mr. Simser. I'm so focused on our long weekend here. I appreciate this. As Mr. Chair, I'd like to move for the admission of what was marked as hearing exhibit 1506.
Any objections?
No objections.
So moved.
Thank you. And we've got hearing exhibit 129 up. Thank you. I'm looking at pages 21 and 22, please. I'm not sure if you'll need to actually look at this, Mr. Pascucci. We can if we need to, but I'd like to discuss the issue of data parity, which is addressed on these 2 pages. I discussed the issue of raw versus billing quality data with Mr. Pollock on Tuesday. I believe it was Tuesday, so I'm not going to ask you about that. Under the company's AVPP proposal, an aggregator must confirm that a customer's distributed energy resource, or DER, is not already enrolled or participating in another load management program, correct?
That's correct to the best of my understanding, yes.
Okay, thank you. And for the sake of the record, in case you want to check your understanding later, that fact appears in hearing exhibit 118, attachment DEE1, Rev 1 at page 2. We don't need to pull that up. So when a customer shares their data with an authorized third party through Green Button Connect, assuming they're able to do so successfully, the data they share does not include information about other load management programs the customer might be participating in, correct?
I don't believe so, no.
Okay. But the Green Button Connect standard allows a utility to share program enrollment information like this through Green Button Connect, correct?
Yes, I believe so.
Okay, but because the company does not share this information through Green Button Connect, VPP aggregators will need to try to get this information from customers themselves, correct?
Yes, they would probably need to get it from customers another way than Green Button Connect. I'd agree with that.
Okay, thank you. And if a customer mistakenly tells an aggregator that they don't participate in a load management program, but it turns out that they do, that customer would be disqualified from participating, and the aggregator would need to enroll another customer to replace them, right?
Yes, I believe so. And my only pause there is I'm not very familiar with our VPP proposals. My testimony didn't really deal with that. It was Mr. Pollock. So based on our previous discussion and my understanding of what we've proposed, that you must not be part of an existing program and that a customer and the third party would need to know, yes, if a customer mistakenly told them they were not or they were part of one, that could create a challenge for our third party aggregator, yes.
Okay, thank you. And would you agree that VPP aggregators incur some costs to enroll customers in their VPPs?
Objection. I think Mr. Pascucci has made it clear that Mr. Pollock is the VPP witness and that the questions regarding VPPs should be directed to Mr. Pollock.
Mr. Dunbar?
Yeah, I understand that, and I'm not asking for details about the VPP program. I'm just asking if this is more just, I'm not asking for a detail about the program. I'm just asking if a VPP is doing business, any business usually incurs costs to acquire customers, and I'm just wondering if he would agree with that kind of simple statement.
Overruled. You can answer.
Yes, I think I'd agree with you, Mr. Dunbar, that you would incur some sort of cost to acquire customers. Yes.
Oh, okay, thank you. So I recognize that the company agreed in the AVPP settlement not to act as an aggregator for the time being. But if it were to act as an aggregator in the future, the company would already know which customers were enrolled in load management programs before it ever started reaching out to customers, right? Because that information is just in the company's records, right?
Objection relevance. We're not asking to be an aggregator in this proceeding, and that's all speculative.
Mr. Dunbar?
Thank you, Mr. Chair. It's Mission Data's position that a disparity of data continues to exist between what the company has access to in its own records and the data that it provides through Green Button Connect. And this is one example of that disparity, that the company already has records of what programs customers participate in, but as Mr. Pascucci acknowledged a minute ago, they don't share that information through Green Button Connect, and that's going to cause problems now, and it could cause bigger problems in the future if the company gets authorization to be an aggregator.
I'll allow it, but let's not go too far.
Okay. Would you like me to repeat the question, Mr. Pescucci?
Sure. Thank you, Mr. Dunbar.
Okay. Okay. In following Chair Blank's directives, I'm just going to ask one more question on this specific issue, get to the heart of it. So the situation we just discussed, in which an aggregator, a non-Excel aggregator, enrolls a customer who mistakenly thinks they're not participating in a load management program, but they are, that would never happen to the company if the company were an aggregator, right? Because that information is in the company's records.
It's possible. I would say in a speculative world in which the company is an aggregator and the company is providing the same data through Green Button Connect today in that future state, if the company's program management team managing the VPP aggregation program or offering had access to all of the company's files, yes, it could. It's also possible that the company's VPP aggregation team may not have full unfettered access to all of the company's information.
Okay. That's a good flag for any future proposals. Thank you. Do you agree with me that we don't need to pull it up, but the commission's rules require the company to share standard customer data through Green Button Connect, correct?
Yes.
And would you agree that if the commission clarified that standard customer data includes all information that VPP aggregators need to enroll customers, then the company would need to provide this enrollment information through Green Button Connect? Do you agree?
I should probably clarify. I believe that the rule does require information to be provided. I don't believe the rule specifies Green Button Connect is how it must be provided. So apologies. I think I misanswered your last question, and I should have disagreed with the rule requires that the information be provided through Green Button Connect. I'm not familiar with that specific requirement. To your specific question here, that should the commission clarify that program participation or any specific data point is standard customer data, I think the answer to their question is yes, the company would need to provide that information to customers and authorized third parties.
Okay, thank you. And you're right, I was being slightly imprecise. The rule does not mention Green Button Connect, but it says it mentions an electronic machine readable form. And so it's my understanding that the company considers Green Button Connect to be the way that it complies with Rule 3027. Do you agree?
Yes, I think I would agree that Green Button Connect is one form of machine readable data provision.
Okay. Okay, thank you. And we'll talk a little bit more about those other forms in a bit. I'd like to talk about I'd like to talk about customers' rate schedules. So if a customer is able to successfully share their data with a third party through Green Button Connect, does the information provided include the rate schedule that the customer takes service on?
I do not believe rate schedule is included in that information today.
Okay. If we could please pull up hearing exhibit 1500. attachment MEM7. Thank you, Ms. Crane. And I'm looking first at page 1 at the question. So this was attached to Mr. Murray's testimony. This is a company data response, so I don't need to enter it into the record. It's already in it. But the request 3-1A asks, does the company provide any method for customers to access their applicable retail rate in an electronic machine readable form? Please explain in detail. Do you see that, Mr. Pascucci?
I do, yes, Mr. Dunbar.
And Ms. Crane, if we could scroll to the next page, the answer to A there says, no customer rates are available in the company's tariff sheets, which are published on the company's website. Do you see that?
Yes, I do.
Okay, so going back to Green Button Connect, the authorized third party who receives a residential customer's usage data wouldn't know if the customer is on Schedule R or Schedule RETOU, correct?
Not from the Green Button Connect data alone, no.
Okay, but if the third party wanted to model potential energy savings for the customer based on installing say a heat pump or a battery, the third party would need to know what rate schedule applies to that customer, right?
Yes, and I think the third party could get that information from the customer directly that they were speaking to, or through a bill. There are, I think, other ways they could receive that information.
Okay, is there so looking at the tariff sheets, which is what this data response points to, is not enough to tell what rate a particular customer takes service on, right?
No, I don't think so. You probably need more information than just the tariff sheet.
Is there any way for a customer to determine their applicable rate other than consulting their monthly bill?
I'm not sure. I'm not sure if that information is something that is displayed within, for example, like My Energy Connection or My Account.
Okay. Do you agree that the Green Button Connect standard allows a utility to provide information about a customer's applicable rate?
I believe that's correct, yes.
But the company's chosen not to do that in its Green Button Connect implementation, correct?
Yes, that's correct.
And thinking again about Rule 3027, would you agree that if the commission clarified that standard customer data includes the rate schedule that applies to a customer, then the company would need to begin providing this information through an electronic machine readable form, which is likely going to be Green Button Connect?
Yes, I'd agree.
Okay, thank you. Okay, I next want to talk about the authorization request URL. And I realize this is a bit technical, so hopefully we can make it through here together. So in the context of Green Button Connect, Mr. Murray raised the issue of an authorization request URL, and you responded to this issue just very briefly on page 16 of your rebuttal testimony. Yeah, sorry, if we could go back to 129, thank you. On page 16. And you can refresh your memory if you need to. Can you please describe what an authorization request URL is in the context of Green Button Connect?
Ms. Crane, would you mind scrolling down just a little bit more? Thank you very much. I'm not sure if that's the last line on the page. Could we go just so that, okay, thank you. My understanding, I'm not a technical expert in Green Button Connect. My understanding is there are two forms of authorization URL. There's one where the customer is authorizing the transfer of data, and then there is an authorization URL used by a third party as well. So I was not sure, Mr. Dunbar, which authorization URL you were specifically referring to there.
Okay. So I was referring to the type of authorization URL that an authorized third party can give to a customer. And when the customer clicks that link, clicks that URL, it takes them to a page on the Xcel Energy website and on that page is where the customer can authorize data sharing. Is that your understanding?
My understanding is that could be a type of authorized URL or authorization URL.
Okay. And so speaking of this type, all of my questions will be in that context. So you agreed that the authorization request URL we're talking about takes a customer to a place on the company's website where the customer can authorize data sharing. When the customer clicks, well, sorry, let me pause. Does the company offer that type of authorization request URL?
I do not believe that we offer that type today, no.
Okay. So when a customer tries to authorize data sharing to a third party, let's say Acme Energy, the company's systems do not send an access token to Acme Energy so that Acme Energy can begin accessing that customer's data, right?
That's correct. My understanding is if, in your case, your example, Acme Energy wanted to receive my data, the company requires that I go on, I first authorize Acme Energy or Acme Company to receive my data, and Acme Energy is required to become an authorized vendor within the portal, and then they can receive that data.
Okay, thank you. And is it your understanding that if the company sent an access token to Acme Energy, then Acme Energy would know immediately that you had shared your data with them, and they would know exactly which data that they're receiving is yours?
I'm not technically knowledgeable enough to follow Mr. Dunbar if that's exactly how it would work or not.
Okay. You're the witness for Green Button Connect, correct?
I am the witness for Green Button Connect in this proceeding and responded to Mr. Murray's critiques of our Green Button system. I would say my understanding is that token that you are discussing is not a requirement for Green Button Connect. It is not something the company is not in compliance with. Whether it works exactly as you described it and would allow the functionality, I'm just not technically savvy enough to know the answer to that question.
Okay. So if you're not providing an access token, so let's say 1,000 or even 100 customers within an hour went to the company's website and tried to share their data with Acme Energy, right? Acme Energy's got the best VPP offering on the block. Folks are excited. How is Acme Energy going to know whose data they're receiving and who's authorized them? They wouldn't know that information without the access token, correct?
My understanding of how the authorization process would work is these 1,000 customers would go sign into my account. They would log in, they would authorize Acme Energy to receive it. Acme Energy on the other side, being an authorized third party within the system, would then have authorization to pull the data from those customers. So presuming Acme Energy knows who those customers are, presuming those customers have granted Acme Energy access to their data, the facilitation takes place through the Green Button Connect platform.
So it's my understanding that if there were you don't have a super common name, but let's say there were 3 Mike Pascucci's who authorized to share their data within that hour, Acme Energy, without the access token, Acme Energy would have no idea which Mike Pascucci was which, right? With the access token, all of the data would be matched to the correct customer automatically and seamlessly, but the company doesn't authorize that. And so wouldn't you agree that that's not really scalable without the access token? It's not scalable for aggregators to get large amounts of customer data?
I don't think I agree that in order to scale this, you have to have a token whereby the third party sends the link to the customer. And if I'm following you correctly, the concept is, in order to scale Green Button Connect, you need to have a access token that's provided by the third party to the customer that authorizes it. I don't think I agree that that's the only way to scale the product. We can seamlessly today provide data or make available to authorized third parties data that they have been authorized to receive by customers.
If we could, I'd like to introduce what's been marked in Mission Data's box as hearing exhibits 1508 and 1509. And these were shared as data responses to, or excuse me, as attachments to the company's response to Mission Data 8-7. They were marked confidential. We worked with the company to redact the information that made it confidential. So these are the public versions. Thank you for pulling these up. I ordered them out of order. I labeled them out of order. But I'd like to just show you that 1508 is attachment A2 and 1509 is attachment A1. Sorry for the confusion. And oh, I'm sorry. I must have
think
missed.
1507 has a public and confidential version with the
Thank you, Ms. Crane. Yes, 1507 and 1508. So I wasn't mixed up. All right, I wasn't out of order. So yeah, if we could pull up 1507 and 1508. Okay, so 1507 is attachment A1, and this is, we asked for the communications that the company said it had with some third parties who had contacted the company's technical support regarding Green Button Connect. Do you recall that?
I do, yes.
And maybe we can just look at the first page so that you can see that it is what I'm saying it is. Does this look familiar, Mr. Pascucci?
Yes, it does.
Okay. And if we could, and so I'd like to move for the admission of 1507, Mr. Chair, please.
Any objection?
No.
So moved.
Thank you. And I'm not going to talk about 1507 today. So if we could look at 1508. And as I mentioned, there were 2 sets of communications. If we could scroll to page 2, please. So, Mr. Pascucci, does this look familiar as the other email chain of communications with the green button support?
Yes, it does.
Okay, thank you. I'd like to move for the admission of 1508.
Any objection?
No objection.
Thank you. And if we could scroll down just a little bit, Ms. Crane, to the middle of the page. So in this second paragraph, before I read it, there's an abbreviation SP that stands for service provider. You can correct me if you disagree with that, Mr. Pascucci, but do you see that second paragraph? It says GBC is not designed to pull a population at bulk, but singular customers per their authorization. When a SP service provider is pulling customer data one by one, they should know who that customer is to store the subscription ID against anything they have in their system. GBC is manual of a single user who authorizes them. Do you see that?
I do, yes.
So do you share the belief of this support team member that Green Button Connect requires an authorized third party to manually pull data from individual customers one by one?
I have no reason to disagree with the technical team's understanding here.
So would it surprise you to learn that the Green Button Connect implementations of many other utilities allow third parties to automatically pull data from multiple customers in bulk?
I would have no reason to doubt you, Mr. Dunbar.
Okay, thank you. And would it surprise you to learn that if public service provided an access token upon a customer authorizing their data sharing, if that access token is sent to the third party, then there would be no need for the third party to store their subscription ID against anything they have in their system. They would just immediately know whose data they were receiving.
It's possible. I'm not familiar enough with how the different ways you could configure a Green Button Connect program to know for sure.
Okay, and last question on this. Does it surprise you to learn that one of the main advantages of Green Button Connect over Green Button Download is that Green Button Connect allows authorized third parties to automatically retrieve data from many customers in bulk?
I don't know that I would say it would surprise me to learn that, no.
But the company's not doing that with its Green Button implementation, correct?
I think what you're asking me is or what we're saying here is the company. I guess I'm slightly confused by your question, Mr. Dunbar, and I apologize. So I think, or is what you're asking me that the company does not utilize a system in which it pushes the data en masse to the third party, or that the company system as of today does not allow a third party to pull en masse the data? And I'm sorry, as you note, it's technical, and I think there have been many times throughout this proceeding that we have all talked past each other here. So I would prefer not to do that here if we can.
No, I certainly appreciate it. What I'm asking is what I'm getting at is that this support team member seems misinformed about the purpose of Green Button Connect. Green Button Connect download my data option that allows one-time manual downloads of customer data. The whole purpose of Green Button Connect is to allow customers to automatically share their data with an authorized third party. And when we're talking about a VPP program where third parties are going to enroll hundreds of customers in programs and need to verify their usage, it's not going to be feasible for them to download individual customers' data. They're going to need to do that on a large scale. And I'm just asking you to confirm that the company's not allowing them to do that today, right?
I don't have the technical knowledge to know as to whether this is a function of the company does not allow you to pull en masse, or whether the company is not facilitating and pushing that data en masse, or whether it is a function of if the developer could create, my understanding would be like an API that could pull en masse. I'm not technically savvy enough on the details of how it works to be able to tell you one way or another, Mr. Dunbar, if this is the company doesn't offer a service, or the service would be in the company's design, the responsibility of the provider to do that.
Okay, thank you. Well, hopefully maybe you have a chance to review Mr. Murray's testimony again. I'd like to change topics about halfway through. Hopefully that's promising news to everyone. Can we please pull up hearing exhibit 103, attachment ZDP Rev 3? And Mr. Pascucci, this is the distribution system plan. I realize that this was sponsored by Mr. Pollock, but this is the page that lists the different options for sharing customer data, as we'll see in a moment. And Ms. Crane, I believe Rev 3 was introduced on Tuesday, so we can look at Rev 2 if that's Rev 2 is probably what's on the spreadsheet.
Rev 3 was introduced this morning, and it contains the corrections to the chart I believe you're about to come to, Mr. Dunbar.
Okay.
Sorry, it's just taking a minute to load. We'll be up in a second.
No problem. Thank you. And I'm looking for page 123, please. Thank you. If we could scroll down just a little bit so we can see that table. Perfect. So as I said a moment ago, Mr. Pascucci, this table 20 lists the different data sharing methods the company offers, correct?
Yes, it does, for electric energy.
Thank you. So if I'm a VPP aggregator and I'm trying to determine how well my VPP performed during an event, which of these methods can I use to access the historical usage data of the customers who have enrolled in my VPP?
I believe you would be able to access that information through Green Button Download, Green Button Connect. Presuming the customer provided you access to it, you, I believe, could use the Xcel Energy web portal or the third-party application via Xcel Energy's Launchpad.
Okay, so thank you. So I agree with you on Green Button Connect. If for download my data, that would mean, or excuse me, Green Button Download, that would require a customer to go onto the website and download a file and email it to me, right? If I'm the aggregator?
Yes, that's correct.
Okay, and same with the portal, right? If I'm the aggregator, I don't have access to the customer's view of the web portal, right? The customer would have to log in and send me some information, right?
Yes, presuming the customer didn't give you their login credentials and allow you to log into their account, yes.
Okay, thank you. And the Xcel Energy Launchpad, that's based on 1 second interval data. That's real time, right? So that wouldn't give me historical data, correct?
Yeah, that's fair. I think you're correct there, Mr. Dunbar. Yeah, I don't think you would be able to get historical data that way. Apologies.
Okay, that's okay. Thank you. So just going back to the two things you mentioned, the Green Button Download and the portal, if I'm a VPP aggregator with several hundred customers enrolled in my VPP, it would be very burdensome for me to ask hundreds of customers to download their data and send it to me so that I could verify my VPP's performance, right?
Yes, I'd agree.
Okay, thank you. I'd like to talk next about my energy connection, and we can pull this down, Ms. Crane. I think we don't need to look at anything for the moment. So one service the company offers to allow customers to access their usage data is My Energy Connection, correct?
Yes.
And that is a mobile app that customers can download to their smartphones from the Apple or Google Play stores, correct?
Yes, that's correct.
And we can pull it up if we need, but do you recall that Mr. Murray pointed out that at the time we were finalizing answer testimony in June of this year, the company's My Energy Connection app had a rating of 1.8 stars out of 5 on Apple and 1.9 stars out of 5 on Google.
Yes, I recall that.
And do you happen to recall Mr. Murray included several screenshots of some of these reviews? One of them was dated in February 15th of this year that stated, in part, unfortunately, the latest app update broke the real-time usage feature, which is the primary use of this app. Does that ring a bell?
Yes, it does.
You didn't address the app's poor rating in general or this review in particular in your rebuttal testimony, did you?
No, I did not.
Okay. And do you recall that one of Mission Data's recommendations was for the commission to direct the company to fix all known bugs in the My Energy Connection app?
I do, yes.
Okay. And you didn't respond to that either, correct?
I did not directly respond to that recommendation, no.
Okay. Thank you. Okay. I have one more topic. It's a little bit long, but just one more topic. The home area network, which I'll refer to as HAN. If we could please look back at Mr. Pascucci's rebuttal, hearing exhibit 129 at page 23. Thank you. So at line 19, if we could scroll down a bit, please. You state, Mr. Murray is attempting to impugn the overall integrity and functionality of the HAN service by identifying a minuscule number of customers that today cannot fully utilize the functionality. In other words, for the overwhelming majority of residential customers, the system is readily available to provide insights and tools. So before we dig into this, do you recall that another one of Mission Data's recommendations was for the commission to direct public service to hire a consultant to report on the experiences of a random sample of customers trying to share their data with a device of their choosing through the HAN?
Yes, I do.
But you didn't respond to that recommendation either, correct?
I did not directly respond to that, no.
Okay, thank you. So in order to use the HAN functionality, a customer must have one premise, one account, and one meter, correct?
Yes, that's correct.
So any customer who has more than one premise or more than one account or more than one meter cannot use the HAN functionality of their meter, correct?
Generally, yes. It would be possible for a customer to set up multiple accounts and multiple logins if they wanted to have separate meters done, but to use one account for multiple premises, no, you could not.
Okay. And the company doesn't know how many customers cannot use their meters HAN functionality, correct?
I would disagree with the premise that they cannot use their HAN. But I would agree that yes, we don't have a number of customers. However, the types of customers that we believe would be impacted by that are relatively small. A relatively small amount of the, I believe it's roughly 1.5 or 1.6 million customers, electric customers that we have.
Okay. Well, maybe you could explain what you mean by the customers cannot use their HON, that you disagree that customers cannot use their HON, because I thought we just agreed that you can only use the HON functionality if you have one meter, one account, and one premise.
I was clarifying or attempting to clarify in there that yes, without the creation of the second account for each meter or an additional account for each meter, you would not be able to create one account. Like I couldn't create if I had multiple premises, I could not create one account for myself that could manage the HON for all of my premises. Yes, that's correct.
Okay. Did Public Service ever propose, or did the commission ever approve of these limitations on HON functionality?
I don't think we ever explicitly stated that HON functionality would be deployed in stages. And what we did was balanced our deployment of HON functionality to where the vast majority of customers would benefit from it. And we didn't seek explicit approval to do it that way, though.
Okay. If we could scroll to the next page, page 24, please. On lines 6 and 7, you state that that offering HON functionality to all customers does not appear to be cost effective. Is that an accurate characterization of that statement?
Yes, based on our understanding today, it would not be cost effective to do.
Okay. And in the AGIS settlement, or the AGIS settlement in proceeding 24A-0547E, did the company commit to offering HON functionality to all customers, or only to customers that it would be cost effective to offer such functionality to?
I believe in that settlement, we stated that it would be available to all customers. What I'm not saying in my testimony here is that the company will never provide that functionality. The company is providing the functionality that is cost effective within the budgets that we have for programs at that time.
Okay. I'd like to get a little more clarity on, well, actually, I'm gonna, in the interest of time, I'm gonna skip ahead for the sake of everyone's weekend. If we could look at page 25 of your testimony at line 8. So here you respond to Mission Data's observation that commercial customers will be particularly affected by the limitations on the HON's functionality. And you state, the type of customer most likely impacted by this issue would be large commercial customers with multiple premises and locations, such as big box retail stores. These customers are likely to already have energy management systems, consultants, and/or tools that provide similar functionality. Do you see that?
Yes, I do.
Do you know how many commercial customers have an energy management system that provides them with real-time energy usage data?
Off the top of my head, no. But the information I provide here was feedback that I had received in talking with program management staff and other employees at the company who have more familiarity with how these customers work.
Okay. Isn't it true that there's probably many commercial customers who are using Xcel Energy's Empower Intelligence service?
I'm sorry, could you ask me the question again, Mr. Dunbar?
Yeah, are you familiar with the Empower Intelligence service?
No, not really. Not in any detail.
Ms. Crane, I'd like to pull up, please, from Mission Data's box, what's been marked as 1509. So, Mr. Pascucci, this is an information sheet about the Empower Intelligence Service offered by Xcel Energy. And this was downloaded from the Xcel Energy website earlier this week. It's a 4-page information sheet. Mr. Chair, I'd like to move for the admission of 1509, please.
Any objection?
No objection.
So moved.
Thank you. So, Mr. Pascucci, have you seen this information sheet or other marketing materials for Empower Intelligence?
I have not, no.
And this used to be called InfoWise. You're not familiar with, are you familiar with InfoWise?
I've heard of the name. I'm not familiar with the program, no.
Okay. Okay. Well, I'm surprised to hear that, but we'll see what we can do here.
Can I check in for a sec, Mr. Dunbar? How much do we have left? We're about an hour in. I'd like to have a hard stop around 3:15. Can you find a good break point in the coming 10, 15, 20 minutes?
I will definitely be done by 3:15 if
that works
earlier.
Thank you.
Yeah, thank you. Okay. Well, let's see what we can do here, Mr. Pascucci. So maybe you've had a time to skim over this while I was talking to the chair just now. On the first page here on the right, there's a Bloch quote, and the first one there is a quote from an energy manager in manufacturing. Do you see that?
I do, yes.
And it says, I can see how much energy we're using at any given point. Don't need to read the rest. So would you agree that the Empower Intelligence is a Xcel Energy service that allows commercial customers to view and track their energy usage?
It appears to be, yes.
Okay. If we could scroll to page 4 of this document, please. And I'll give you a minute to look at this, Mr. Pascucci. This is, as you can see at the top, still about the Empower Intelligence Service. And here on page 4 is a table that shows the different insights that customers can get depending on whether they sign up for the monthly, daily, or real-time option. Do you see that?
Yes, I do.
And the first bullet point in the first box there says easily access historical usage data at 15-minute intervals. Do you see that?
Yes, I do.
Would you agree that Green Button Connect, when it's working properly, also allows customers to access their historical data at 15-minute intervals?
Yes, I agree that the company's Green Button Connect would allow you to do that.
Okay. And further down in this table on the fourth box, the fourth box is labeled Manage Peak Demand. The second bullet says Track Demand in Real Time. Would you agree that a customer using the home area network, again, assuming it's working properly, can also track their demand in real time?
Yes, I believe they'd be able to do that.
Okay. And if we could scroll down to the bottom of this page, please, Ms. Crane. Do you see this list of the different fees and service options here, Mr. Pascucci?
Yes, I do.
So I know you said you weren't intimately familiar with this program. So, is it, I will represent to you that these fees do not appear in the company's tariffs. Does that make sense to you?
Yes, that seems fair. Yes.
Okay. And the reason they don't appear in the company's tariffs is that this is an unregulated service offered by Xcel Energy. Does that sound right?
I believe so, yes.
Okay. And this being an unregulated service, that means there's third parties who could legally provide the same services potentially as Empower Intelligence without infringing on the company's exclusive service territory or anything like that, right?
Yes, I believe the provision of energy services or energy monitoring is something any third party could offer, yes.
Okay, great. Thank you. Just a few more questions on this, I promise. If we could go back up to page 1 of this document. The second paragraph there reads, businesses and institutions often lack the tools and capabilities to manage energy usage and costs. Many have limited resources or time to conduct reporting or gain budget insights due to barriers in obtaining usage data and analytics. Do you see that?
I do, yes.
So I'd like to focus on that phrase. You probably heard it in my voice, due to barriers in obtaining usage data. Would you agree that when the commission directed the company to implement Green Button Connect and to implement the HON functionality of its advanced meters, one of the commission's goals was to reduce or eliminate barriers to customers obtaining their usage data?
I won't try to speak for what the commission's intent is in what they do, but I would say providing information through Green Button Connect or through the HON, part of it is to make energy information more accessible to customers, yes.
So in your mind, what is this referring to? What barriers are there to customers obtaining their usage data from the company such that a service like this is needed?
Barriers to obtaining the usage data. Having not written this and not been the person that works on the program, I could speculate there may be barriers in you obtain the usage data. You could download your data, but while you've obtained that, you have not also obtained any analytics associated with that. I'm not sure if I think you can read it as it's barriers in obtaining usage data and analytics. There's more to understanding your energy than simply having the numbers on the spreadsheet in front of you. And so depending on the size of your operation, if I'm a two-man cabinet manufacturing company, I may not have the ability to regularly obtain my data and analyze it. Versus if I am Home Depot, I probably have a much easier time obtaining and analyzing my data.
Mr. Dunbar, I just want to ask 2 questions on a foundation basis. When did you pull this off the Xcel Energy website?
Earlier this week.
And have you confirmed that this product is available in Colorado?
Yes, I was very sure to make sure I was on the Colorado site because, yep.
Can you provide the URL when we break?
Yes, of course.
Thank you.
Yeah. Mr. Pascucci, given that Empower Intelligence is an unregulated service offered by Xcel Energy, would you agree that an economic incentive exists for the company to make it easy for customers to use Empower Intelligence, but make it difficult for other third-party services that compete with Empower Intelligence to access data?
No, I wouldn't agree with that.
The company doesn't have an economic incentive to make sure that its services that it charges fees for succeed?
I think that's a different question. Yes, the company has an incentive for the products and services it offers to be successful. I disagree with the premise that the company has an incentive as a regulated utility to bias its products over a third parties or any others. We're a regulated utility. I think that would be a challenge to ever have to explain to our commissioners if we were biasing our products against someone else's.
I agree. That's all I have. Thank you, Mr. Pascucci. Thank you, commissioners.
Thank you, Mr. Dunbar. Mr. Simpson, do you have much redirect, or can we take it up Tuesday?
I think it would be helpful for us to take up redirect on Tuesday, if you don't mind.
All right. Any final matters before we break for the long weekend? Ms. Dundas.
Thanks, Chair. Really fast. The legal assistants wanted to confirm a couple of the exhibits that were brought up this AM. I know that I've heard from the company that Exhibit 140 will be something we'll address on Tuesday with Mr. Paquette, but there was also Exhibit 103 ZDP1 revision 3 and 142. Are those something you plan on moving for admission later?
And 141C.
Okay. So that's something we can take up on Tuesday then.
Yep, sounds good.
Good.
Anything else before we break? Hey, hope everyone has a great weekend, and we'll see everyone on Tuesday at 9. Thanks.